Hello. Well, my client is setting up a first private township in West Bengal. As usual, any big project, vultures pounce in. They have set up one of my neighbors. I want our walls be divided, my lord. People are walking in motion, my lord, motion. My lord, let some get some precedence, my lord.
Have you indicated the urgency?
Yes, my lord.
The urgency and
On a list.
Urgency, I'll indicate, my lord. I'll give it to your lordship.
please hand over the slip.
Upgradation,
Upgradation, please hand over the slip mentioning the urgency.
mentioning that it
In writing,
the
please
urgency.
mention the urgency and
My lord, extremely sorry, my lord, I am mentioning the matter. Matter already disposed on 5th January 2026.
disposed upon.
5th January.
Yes.
On that day, my lord, I missed the matter. I am appearing for the respondent number 5, 7 and 8, my lord. Your lordship already directed to dispose of the matter, make an application before the appropriate authority. So, my lord, my humble prayer, let my name be recorded. Otherwise, it is very much embarrassing to me because the client, what answer I should.
And now it has been uploaded.
No, I have went to the officer that is till now it has not been signed. That's it. I'm grateful, really. Otherwise, wrong message will go to my client, Lord. Because I could not appear. I'm grateful.
Restoration application.
Hand over the slip.
Listed motion.
Listed motions, please hand over the slip.
May I permit to mention two matters for upgradation?
Upgradation, hand over the slip indicating the urgency.
Grateful.
Yes, Mr. Banerjee.
Adjourn motion. Milord, a report was called for from the government in July. Milord, the matter was made returnable in September. For some reason, Milord did not appear after that. Milord, this matter pertains to the land, Milord, which is now occupied by Metro Cash and Carry, Milord, on bypass. Milord, I purchased the land. Milord, apart from the land, Milord, owned by Metro Cash and Carry. Milord, after purchasing, Milord, a measurement was undertaken and it was found that the land which was sold to me, Milord, does not exist. Milord, this happened because of Milord, the Metro Railway. Milord, they acquired some land. What they acquired and what they possess, Milord, there is a Milord, huge gap between that. What they actually acquired is much less than what they actually took possession of. That is why, Milord, this
Actually,
difficulty.
Mr. Banerjee, a hearing matter.
Milord, a report has been called for. Milord, let the report come. Milord, we have information. I tell you, Lordship, I cannot tell that in open court. Though, Milord, may I just submit this? Milord, the report is in our favor, which is why the report is not forthcoming. Milord, let this matter
Report
appear.
has not been filed.
No, since July.
You have not been served with any copy
No,
of the report
no.
to be mentioned.
So grateful, Milord.
Well, we are permitted to mention two matters actually. Inclusion in the list.
Motion.
Yes,
Hearing.
motions.
Motion, hand over the slip.
HON'BLE.
Motion. Hand over.
Motion.
My lord, I pray for apology. Yesterday I could not appear at the time of calling.
You are not there.
My lord, there misunderstand. I thought the matter was urgent for day.
No. The government pleader came. So I have directed the government
my
pleader
lord.
took 1 week's time.
And
so I think I fixed it on 13th or 14th.
14th.
Please check up.
14th.
14th. Yes, he was there.
We are informed.
All right. So come on 14th.
My lordship, may I
missed it, my lord.
permit to mention for inclusion, it's contempt application, my lord.
Hand over the slip.
May I be permitted to mention an intervener application? An intervener application, Your Lordship, the writ petitioners are trying to dispose of the property. They are members of the same HUF and they have not impleaded us in this writ petition.
Application.
They have
Yes.
great.
I am indicating the urgency.
Hand over the slip. Motion.
Motion.
Please call the list.
May I submit your may I mention
Yes.
Your Lordship, I am the petitioner. I have filed the writ petition number
What do you
2.
want?
Your Lordship, it has appeared on 5th and it has been dismissed for default. Upon on,
File an application.
sir, I have a mentioning. Kindly
File
consider
an
the story.
application. Yes, call the list.
I am happy. On the statement. But, yesterday it was taken up. My lord has asked me. My lord, I draw your lordship's attention to few portions of the list of my petition. My lord, I draw your lordship's attention to paragraph number page 13, paragraph number 22.
No, you sought for instructions whether you want to withdraw it or not.
My lord, I have sought, but according to this, my lord,
According to you are maintainable.
my lord,
According to you, it is maintainable.
yes.
Then you move on when it's
My lord,
all right.
my lord, kindly sees, my lord, kindly sees, my lord, don't take me amuse, my lord.
No. Move
My
on
lord,
minutes.
kindly sees that page 13, my lord.
13, yes.
13, what they have done, my lord, they have granted me patta. I was outstate. I was being criminally proceeded with for my lord, for destruction of some property according to them, and I was, my lord, fined for that. My lord, thereafter I didn't return. That is a fact. My lord, what happened after that, my lord? They took the land and distributed my land, which was a patta land, which was, my lord, directed by the governor to record in my favor. They have took that land and distributed to others as patta land.
Under what provision?
That is not given, my lord. That is the
Distribution by way of patta is under what provision?
under section 49. But my lord, the land belongs to me. That is not a vested land.
That's an illegal act according to you,
Yes, my lord.
performed by an authority under the specified act, because this distribution has to be under section 49. So if there is an illegality done while distributing the patta under 49, so it's an authority exercising powers under the specified act. Land Reforms and Tenancy Tribunal is the authority.
But my lord, they have taken, my lord, I have, my lord, kindly, my lord, I'm not on that distribution, my lord. They have treated that land as a vested land, because once they have given to me,
What
my
is
lord,
the,
they have
what is your prayer? What is
lost
your-
their.
Please kindly come to your prayer. What is your prayer here?
Yes, my lord, kindly sees,
Yes.
my lord, for prayer A, my lord,
Yes.
issued the set aside the letter dated 29/8/2025, issued by the additional district magistrate, district land and land reforms officer Nadia, where they have stated that we have distributed the land as patta. Secondly, my lord, and also the BLLRO's,
Show me that order.
my lord, that is at page 65. My lord, 69.
69.
My lord, kindly sees the last but one paragraph.
Yes.
As per the ROR 555, area of 34 is presently recorded in the name of Bhakto Shamadar, son of Shochindra Nath, in Eliar Khotian number 626, which is a Patta Khotian. So, my lord, this Patta to Bhakto Shamadar is given of my land, whereas, my lord, I have been given Patta in 1978 of the same land. They have, my lord, plotted out that entire land and given patta to others. And so, my lord, I have come before your lordship, my lord, with the prayer. My lord, my lord, kindly sees my prayer B. Read order prayer B, my lord, read order direction commanding them to release the land measuring 2 acres in favor of the petitioner as has been allotted to him by the Honorable Governor of West Bengal by deed dated 9/12/1976 as Annexure P2 to the writ petition within a stipulated period. Or they should my lord, pay adequate compensation, because land has been given to me. They have, my lord, treated the land to be wasted land and given patta to others, whereas their wasted land previously given in patta in my favor. That is the difficulty, my lord, we are facing.
But your kindly come to your representation at page 70 and 71.
Yes, that is a my lord, that is a thing which I have already pleaded, that if a person, my lord, yesterday I have
made a representation saying
that is there, my lord.
To give 2 acres of land within the district of Nadia, not for that patta
No, no,
land.
that is,
your representation at
yes,
page
that is,
71.
that is in terms of the, my lord, the,
Portion of the
eli-
whole state land is provided with such, within such patta land, I can construct
my
a
lord-
house
my
for
lord-
my own house.
yes, my lord, kindly sees, my lord,
Where was your patta?
my lord, kindly sees patta.
Yes.
My
I will
lord,
annex that.
that, yes, my lord, that is at page, my lord, 27.
27.
My lord, the deed is at, my lord, though it's a very, my lord, old document, page 24 is the deed in the name of the governor. আচ্ছা ঠিক আছে, না না তা this has been executed in the name of, my lord, governor by the subdivisional officer, land and land reforms officer, Krishnanagar Nodia, at page 27.
That was for agricultural purpose.
Yes, and my
So
lord,
now how can you reside thereupon?
no, I,
That is your prayer now.
oh, my lord,
That is your pra-
I said for
Mr.
release.
Dhol, you were in service.
Yes,
So you did not intend to cultivate. This patta was for cultivation purpose. If you want me to go into merits, I will go into the merits. This was the patta. Now it's for a different purpose which you are making. Admittedly, you are not carrying on cultivation purpose because after that you have joined service.
my lord, cultivation purpose, my lord, I
You
have
see
been,
page 24. What was the purpose for which this patta was granted? And admittedly, you joined service.
yes, I was, my lord,
Mr. Dole, I am giving you an opportunity. Otherwise, I will have to go into these merits. Please apply your mind. I have seen the patta now. You wanted me to go to the merits. I have seen the patta now. And admittedly, your own admission is that thereafter you joined service. So you did not pursue cultivation. So that was the ground for which patta was only given.
but my lord, that was
Now-
cancelled.
Now your claim is also you want to reside, not for cultivation purpose.
Then, my lord, today, my lord, my client has come, my lord, just I have, my lord has fixed it as item number 1. My lord, kindly keeps it on, my lord, Friday, my lord, I will talk to her.
I'm passing it over. Please talk to her because if you want, I can decide it on merits. I'm giving you another opportunity to you. That is why I can decide it on merits also.
My
If you want to press this, I can decide it on merits because whether you are entitled to that patta land, that was for a different purpose. Now you are seeking for a different purpose.
My lord, I am, my lord, pass it
At
over.
12.
My lord.
বারোটার সময় রাখো।
This is my writ petition.
I'm appearing on behalf of the respondent. I'm led by Mr. Amitabh Mitra. He's appearing online.
Madam, I'm appearing for state in this matter.
Yes.
My application, my lord. My lord, in this case, my lord, this is the property. Before I trouble your lordship with the papers, I'll just quickly indicate, my lord, what had happened. My lord, this is with respect to a Salt Lake property. I am, my lord, a society which is carrying out, my lord, certain non-commercial activities, my lord, for the purpose of propounding certain activities regarding Rabindranath Tagore music and all of that. But I made an application before the urban development asking for an allotment of a land in my favor in Salt Lake. Now, as per the terms of allotment, my lord, I pay whatever is the original advanced amount. There is a allotment that happens in my favor. Pursuant to that allotment, I pay the entire salami amount. So that's an undisputed position that I've paid the entire amount. Post that, my lord, they make certain communications addressed to me, asking me to make certain further payments. That has also been paid. Post that, my lord, what was their obligation under the letter of allotment was the execution of a lease deed in my favor. My objection, and I'll take your lordship through the papers, my lord. My cause of action is that the lease agreement has never been executed in my favor till date. In 2009, the allotment takes place. Sometime till 2010, my lord, the payments were made. As late as 2021, there are communications exchanged. There's also an informal communication that happens with my client, wherein he's given the assurance that the allotment will take place in his favor. And allotment was already there. I'm sorry, my lord. The lease agreement will be executed in his favor. And my lord, post that, there were certain hearings that were conducted. I was invited for that hearing. For some, I could go, and admittedly, my lord, I'll not shy away. There was one
That has
hearing.
been taken.
I'm sorry, no decision has, nothing has happened. Nothing has happened. In fact, the last hearing, my lord, there was a communication issued to me wherein a date of hearing was rescheduled. I could not go for that. Admittedly, I could not go for that.
Where is that? Where is the last hearing?
Well, the last notice, my lord, I received, my lord, is page number 51.
Number
51. So the document is at page number 52. 51 was the email issued to me. 52 is the notice.
So this was on 23rd of September 2021.
My lord.
You could not attend on that
I
date.
could not attend.
Then what happened after that?
Post that, I make several email communications addressed to them. I write letters. I write emails
Is
saying
the
why I could
allotment
not go.
cancelled?
No, nothing has been cancelled. If it were cancelled, then my cause of action would have been completely different. But today, there is no cancellation that has taken place, admittedly.
Yes, Mr. Mitso, what is your instruction?
My lord, my instruction, nothing to be worried for the writ petitioner. The difficulty is in the meantime, the plot in question was encroached by outsider, initially partially and then fully. We have taken steps and get the plot encroached free, and it was fenced so that it could not be encroached further. But my junior has a copy of the report of the instruction handing over to your lordship. Kindly come to, there is
That
nothing.
plot now can be allotted to him.
Yes, never cancellation, nothing.
Then
It has
Mr.
to be,
Mitso,
even
only
draft list deed is prepared. It has to be
Right.
handed over to them. Only in between they have initiated the proceeding. This procedure is stopped. My lord, kindly come to page 2 of the instruction report
yes.
by the Special Secretary. Kindly come paragraph 10, 11, 12.
Yes, now everything. You
And
have got a
16
copy
and
of
17, my lord.
Now
We are
it-
ready to hand over the draft list
model
deed.
list deed is also there.
I think my lord, whatever was my grievance, the report
That
pretty
has
much
been addressed.
takes care of that. I don't see any difficulty with that. I was not aware of this stand that they had taken, which is why the writ petition. I, in that case, my lord, only have one small submission to
Mr.
make.
Mitso,
My lord, my suggestion, my lord, subject to your lordship.
yes.
My lord, they have not made special secretary as a respondent. Here, the joint secretary is the respondent number 4. If it could be amended to the special secretary, your lordship can direct the special secretary to hand over the draft list deed to them for waiting approval and execution within a certain period.
Lordship grants me the liberty to, my lord, amend. I'll have that amended by in the course of
Special secretary, instead of joint, it will
one
be
prayer, my lord.
special
So
secretary.
secretary has been impleted, respondent number 1.
My lord, I must have missed.
State of West Bengal through the principal
Yes,
secretary.
My lord, special secretary. Actually, the file is lying with the special secretary.
Special secretary. Special
Yes.
secretary.
He can add another respondent by granting leave by your
I'll do
lordship.
that. I'll not stand it. My only prayer, my lord, is lordship makes it a time-bound process. We'll
Yes. No,
Mr. Mitso, what would be the time to complete these formalities?
my lord, this draft list deed will be sent to them for their approval. Once they approve, it will take some time. So the entire process could be completed within 3 months.
Within 3 months. Why?
Within 3 months, it will be handed over to them. They will approve it.
We'll
If
approve in
there
one
is
day.
any
They will,
modifications
he is
required,
saying he will
then
approve
and
it
has to
in
be
one
executed.
day. Mr. Mitso, he says he will be approving it in 1 day. Then thereafter, how
Thereafter,
much
my lord,
time?
I strictly speaking, my lord, for physically execution of the lease deed registered, how much time your lordship can fix 2 months by March 31.
Or I can do one thing, Mr. Mitro.
My lord,
You give them the draft list deed
within 7 days.
within 7 days, and thereafter and how soon he will return it.
Lordship keeps the writ petition, my lord, pending. Lordship,
No use in keeping
I will need the,
petition pending.
I need the direct. My prayer, my lord, is for the execution of the lease. Lord,
Yes,
them
yes, that
making
will
that
be done. That will be done. If you approve, nothing remains thereafter.
we'll,
My lord, kindly direct, my lord, my suggestion, subject to your lordship,
Petition that
7 days, 7 days.
the execution and other formalities will be completed within certain time. That's
Anyway,
Mr.
for
Mitro's.
abundant caution, Lordship gives me 3
My
days.
lord, my suggestion,
All right, 3 days, 4 days, that can be done.
huh,
Mr. Mitro, can you send them the draft? Can you give them the draft listed by 14th of January?
my lord, since they are the government officer and will be engaged in Ganga Sagar issue,
Said 1 week. You said 1 week that list deed will be
7 days. My lord, kindly direct to hand over the draft list in 7 days. Let
Yes.
them approve within 7 days, and thereafter within
just
certain
to
time to execute.
You approve that by 19th.
Yes. But only to cut short, my lord, could it just be made over to my advocate on record? I think that will be easy. Otherwise, they will issue
No,
it
no,
to
no,
my
no, no,
client.
no, no.
Advocate
No,
on
no,
record.
no.
This is
It has
another
to be to the
No,
petitioner.
no, we will issue it. The client will
No,
issue
no,
it.
no, no, no.
The
Sorry.
draft can be
Sorry,
made over
Mr.
to
Naik.
the advocate on record. The draft only. The
No, 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 no,
approval
no.
and the submission
Mr.
will be
Naik,
by the
as per
petition.
procedure, that has to
Mr.
be handed
Mitro,
over to the party
the-
only.
Cut short.
Mr. Mitro, only one thing.
Hmm.
Is the petitioner required to attend your office to get the draft list deed? How
That
he will
is-
send that?
Well, let Special Secretary,
Mr.
they
Mitro,
will make.
I'm directing the petitioner to attend the office. Attend the office of the special secretary on a
My
particular
lord,
date, hand
my
over
lord,
it to them, and they will return it on a particular date.
my lord.
From that, so when can you attend the office?
Any time, my lord. Next week we'll.
14th.
Yes.
Uh,
There's some, I think, state holidays there, my lord. I just
14th or 12th state holiday.
12th is a state holiday. My
14th,
lord, kindly make it 16th.
14th is the state holiday. Then 15th.
15th or 16th, any time, my lord.
16th, my lord. To be on safer side, 16th.
What is the plot which you applied for? Please show me those particulars.
But DD 27 by.
All right.
Lordship will come to paragraph
By
3,
two.
my lord. Page number 4 of my writ petition. Paragraph 3.
Paragraph 3.
Page number 4. Plot number has been the 4th line, my lord.
DD 27 by B by 2. If
Petitioner E. What is the official address?
No, the official address that's given, my lord, is the same as the other authorities in the cost title, my lord. It says Noban, no, but my lord, possibly, my lord, there's an office also in Salt Lake.
Yes. I think it.
It will be at Salt Lake only.
Mr. Mitra, please ask your junior to furnish the correct address so that they will include that proper respondent.
My lord, I'll supply to your officer
All right.
shortly.
Yes, please supply. Yes, please collect that name and please amend thereafter.
I shall.
তাহলে ওটা না দেখে নিলে
Be grateful.
আমি আসলে দিয়ে দিয়েছিলাম।
I am for the petitioner.
yes.
I'm for the statement.
I am appearing for the private respondent.
For the public road.
Civil suit is
No,
there?
no, no, no.
No civil suit.
I made representation, that is page 16.
1-6. Yes, why have you encroached upon the
Well,
petition?
kindly see their representation, my lord. Kindly come to page 16, annexure P2, my lord.
Yes.
First paragraph, my lord. আমার বিনীত নিবেদন এই যে such and such thereafter নিম্নবর্ণিত বিবাদীগণ দুর্দর্শ প্রকৃতি ব্যক্তি হওয়ায় সম্পূর্ণ বেআইনিভাবে এবং জোরপূর্বক ভাবে আমার বাড়ির সামনে পিডব্লিউডির রাস্তার দখল করিয়া অবৈধভাবে দোকানঘর নির্মাণ করিয়া ব্যবসা শুরু করে। My lord, I am supplying the copy of the present position of the suit property. Kindly see.
I have annexed the photographs.
Yes.
Page 15.
This is the actual position, my lord. The shop room is on the road, admittedly, but behind the shop room, the suit property is in the nature of doba.
But can you encroach upon the PWD?
No, this is the joint property, first of all.
Which is the joint property?
The doba. I am.
Maybe, but you are also the owner of the doba.
Yes.
Maybe, but can you encroach upon the PWD road?
I am not. They have what they have prayed for. My lord, kindly see the prayer portion. For removal of the said unauthorized construction over the PW in
PWD
front of the petitioner land illegally and forcefully, my lord.
Yes. PWD road you cannot encroach upon.
That is another thing, my lord. But kindly consider the behind for the suit property. That is not the what they have admitted. My residential house. That is not the residential house. That is the doba. That is the we are the co-sharer. We and petitioner. I have also right there. They have also right there. I have also right. Because if the illegal construction, if the I have obstructed, that is my land also.
It's an internal dispute. Try to solve it within the family.
Yes, that is true, my lord. But I have also right. This is the I not only that I have been restrained his ingress and egress.
You are undertaking physiculture activities in that doba.
Yes, my lord.
You are undertaking physiculture activities in the doba.
No, that is not true. But that is also illegal. No, I am not. I am not rest.
The reason for this.
I am not restraining
This take
what they have.
instruction from your client. This might be the reason.
Man, what they have admitted, I am
I'm for
restraining.
the state, my lord. It's between the blood relation. The OC concerned, respondent number 8, is keeping a strong vigil over the issue, and no FIR has been registered because
But I know that it's blood relation.
my
and
lord,
this is the
unpartitioned.
Proper forum is civil court, my lord.
What civil court?
Because I have also
I anticipated this.
what they
That
have.
is why I asked you whether there is any civil suit or not.
That
Why file a civil suit?
well, I am not.
This
I am not
enforcement-
only. I am only.
The doba you file a civil suit.
Only that averment that I am not restraining that ingress and egress, my lord.
Yes, I am recording that. The Yes, next.
Item number 4 on behalf of the petitioner, my lord. My lord, this is my evidence of service.
Yes.
My lord, the petitioner made an application under section 10 of the West Bengal Highways Act 1964 for demolition of illegal construction, which has been
For the private respondent.
And I beg to appear on the private respondent, madam.
Yes.
page number 15 is my representation given to the assistant engineer. My lord.
Yes, what steps have you taken?
My lord, after taking instruction, my lord, yesterday I got the beep at 5 p.m. my lord. So, my lord, kindly sometime.
Yes. What is their instruction?
My lord, admittedly, my lord, there is a shop, but not Paka construction. Admittedly, it is there. I should not dispute, my lord. I should not dispute. Both the petitioner and
The petitioner claims to. Call the next matter.
My lord, I am appearing on behalf of the state's lordship.
Item number 5, my lord. Well, I appealing for the petitioner, my lord. In this case, I have made a complaint
How do you
before
take
all
this
the
step?
authorities that my land is situated just within the PWD, 2 roads, PWD and Jila Parishad. Now, they have encroached. The party office has been built.
Who has encroached?
I have made a complaint. Lord, will kindly come to page 41. I have made entire thing clear in this representation. Lord, will kindly text page 41. from last paragraph, my lord, the main paragraph, if your lordship kindly takes at page 42, third paragraph.
Yes.
But that it is pertinent to mention here that property owned by me is between two roads. One being a PWD road and the other owned by Jila Parishad, North 24 Parganas, and the aforesaid illegal constructions are made upon these government lands which is not permissible under the law. The said illegal constructions have completely blocked my ingress and egress from my property to the road and vice versa, as a result of which I am deprived from my right to access to my property. That the illegal encroachment is only blocking ingress and egress of my land, but also choking the said government roads, resulting congestion of traffic and at times even accidents. The such activity is defeating the very purpose of said government roads, and people should be stopped from using the government property. It is further to be noted that said government roads are highway within the meaning of Section 2C of the West Bengal Highways Act 1964, and any unauthorized encroachment of the state government roads is question is illegal and authorized and liable to be removed and demolished by the concerned authority. Now, my lord, I have also given the pictures. Lordship will kindly take, my lord, page, yes, starts from page 23. Well, all our Lordship will kindly see.
So this is encroachment upon the PWD road.
Yes.
PWD and some portion of
Assistant engineer.
Jila Parishad.
Yes.
Which
Well,
respondent?
Yes, ma'am. Well, I have made page 40 also. Well, I have made the representation.
That is the which respondent
Yes.
is the assistant engineer.
Lordship will kindly see, my lord. This is Pradhan Shahi assistant. Well, additional district magistrate has been given, SDO has been given, the PLRO has.
The appropriate authority.
Yes. Well, 2. Respondent number 2.
This two.
Well, office of the
He is
executive.
not the appropriate authority.
Yeah, well, highway, well, he's a
No,
PW.
office of the executive.
The
No.
executive engineer.
Lordship will kindly see, madam.
The assistant engineer is
Assistant
the
engineer.
appropriate authority.
Well, district magistrate has been additional district magistrate. Everybody.
No,
has
no,
been
no,
made.
no.
But,
They are
well,
not the appropriate
but,
authority.
the office of the
Mr.
executive.
Chattopadhyay, this is should be dismissed for not implementing the proper necessary party.
Well, I'm just, well, but state is there, well, only the thing is that, well, this office has received all the representations.
Yes, what is your instruction?
Lordship, I am giving instruction, Lordship. Kindly see, Lordship, already take steps and issue notice to the BLRO.
Demarcation has
for
been done.
And already
But
now,
demarcation,
notice has been sent for identification and demarcation, my lord, on 29
Another
12
problem is that, my lord,
2005, Lordship.
well, I have also filed a repetition that is pending before your lordship only, that is item number 290. Well, previously, well, this was total, well, out of total land, well, I am carrying 24 decimals of land. Well, I prayed for a demarcation, my lord. And at the time of demarcation, my lord, a Panchayat office, my lord, came into my play that this office is on the government land. Well, we said, no, this is not on the government land. Well, subject to correction, my lord.
Your demarcation of a private property.
No, well, it's a acquired land. Well, acquisition was done. Well, out of a big chunk of land, well, I want
Portion
to
was acquired.
yes.
Some portion was acquired,
And
Lordship.
out of that acquired land, PWD road and Jila Parishad road was also constructed. My grievance was that it has to be demarcated. Now, this honorable court directed me for demarcation. Well, after that, we went for demarcation, but they did not produce any papers. Challenging that the procedure, we have also filed this petition. That is also pending. Now, few people has been encroached on the basis of the entirely done by the Pradhan. Entirely. Lordship will kindly seize, my lord.
Said notice, Lordship.
Yes, yes.
And communication is there,
Yes.
Lordship.
Why are you not fixing a date for demarcation?
They cannot fix.
Lordship, actually, my Lordship,
A date
And-
will be fixed. Fix
Yes.
a date now.
Lordship with direction any day, Lordship,
You give a date, I will fix that date.
within 7 days, Lordship.
7 days, give a date.
Lordship.
So today we are on 7th. So 14th, this
14th.
demarcation will be made.
14th, my lord, the
7
holiday.
days you said. 14th is the holiday. 15th,
15th, Lordship.
15th. So I'm fixing
Lordship.
15th as the date of demarcation
Demarcation.
and produce the report on 17th.
And only one thing, madam. Let them come with all documents, because I have also challenged a petition that is also pending before your lordship. So that may be also listed on that.
I'm looking at petition, I do not know about
The problem started. Your lordship knows much
may
better
be.
than me. The problem started from that.
Maybe please
But that was the initiation of the problem, and now it has cultivated to this situation. So that is also before lordship. If your lordship can also fix this, let it be tagged with this petition. Item number.
the petitioner
My is 20. I have annexed the Portia Lordship record of rights at page
LR dag number
Yes, page
682.
682, yes.
The petition 12 decimals.
No, 24 decimals.
24 decimals.
Petitioner claims to be tagged in that way.
No, only the
Next
because
matter.
the issue, Mala, only on the issue.
This is decided, everything can be decided.
No, Mala, that issue has to be decided.
All right, let me see. On that date, I will do. Yes, call the next matter. Item number 6.
My lord, I pray for not today, my lord.
Why?
Advocate record is not able to come, my lord, due to.
You are here. Please start. Yes, what is this?
My lord, I am not advocate record. I am instructed by telephonic call, my lord.
Yes, Mr. Mahato, what is your instruction?
Instruction, my lord, the region, this honorable court directed him passed to the region order. Region order has been passed and
Where is that?
that is page 30, start page 30.
What is the issue?
Issue is he is claiming of payment of compensation of the acquisition of 1965. No representation, nothing, and on the ground of delay, it has been rejected.
Can it be done, Mr. Mahato?
My lord, my lord, the notice.
Utilize the property.
My lord,
It is your
EP
duty to pay compensation.
my lord, EP.
Only that you have paid compensation. Then whether he is agreed, whether he can pay for
my lord,
that can be, you can
my lord,
delay.
my lord, the authority has relied upon the decision of the Supreme Court, explaining, and my lord, if your lordship kindly see, the
Relied upon the decision of the Supreme Court.
Yes.
In a university matter. That's a service matter.
University matter.
Service matter delay can be a ground. That has been distinguished by this Honorable Supreme Court in a land acquisition matter. Where is the decision?
My lord,
Mahato, you know, because there is a distinction in service matter, yes, can be done. Because if that is entertained, there may be various interested third party rights have accrued, not in land acquisition.
After 65 years, he has made the representation. And this honorable directed the in general way, consider it. After 65 years, now what are the materials?
So Mahato, you have taken the property of an individual. The only thing the court wants to know, have you compensated that person? It's the duty of the state.
And the region order does not reflect that.
Then please take instructions. If you have paid compensation, then whether he can have a right to pay for enhancement, that can be considered. You can take the point of delay and other things. That's a different thing altogether. But if you have utilized the property without paying any compensation, Mr. Mahato, without initiating any proceedings,
but
that cannot be done, Mr.
But
Mahato.
there are also several decisions that delay in acquisition proceeding is also fatal, and he cannot claim interest like 12%, 10%.
That is a different thing altogether. That is why I'm saying those are other things. Interest for which period, enhancement, whether it's a different, but the minimum that is required.
Interest also.
All right, I will accept that. But show me the minimum amount of compensation has been paid, whether the proceeding has been initiated. That's the minimum what the court wants to know from you.
My lord, only the annexure that has been annexed in the writ petition, that is the notice under section 934. That is, my lord, thereafter, my lord, nothing.
Award. Show me the award that the award was declared.
My lord, I have to take instruction, my lord.
Please take instructions because this cannot be supported. And more so, a decision of the Supreme Court in a service matter was relied upon.
Yes, service matter. It is service matter.
So service matter stands on a different footing altogether. Because third party rights have accrued, other things for that.
In land acquisition also there are judgment that if third party accrued and subsequently the petitioner came challenging the acquisition.
So if there is a third party rights have accrued, here third party rights have not accrued. Cannot have accrued.
Cannot because the state has taken the possession.
So that's not a third party.
Not third party.
Yes. When
I am for the statement. In this matter, my lord, that is a in this matter, my lord, that is the land was acquired by us, my lord. After that is a landlord certificate, my lord. He paid for page 17, my lord.
Yes.
If your lordship will prepare for enlistment of name for appointment in the list of eligible person of landlords.
Yes.
He filed that application, my lord. That application will be considered by the DM.
No, what is the page 19? Some what
That is
that?
that is the he prior for enlistment of the name for appointment of in the list of eligible person and landlords. In reply to your letter, he inform you that regret that you are careful.
After careful consideration of the keeping in view of the crucial need to extend reasonable opportunity in the to all persons who have been applicable has been affected due to loss of existence such and such. Following decision has been
District magistrate shall also advise to eligible person to enroll their names.
prepared. What has been done?
Nothing, I am seeing nothing, my lord.
2005. No. This is
Those 17 July 2012 কবে का 2007 11 July 17 July.
I think because you file a report as to what steps you have taken. Because he only wants enlistment of his name.
To
whether any
consider
steps-
that aspect, my lord, about my lord, he report is, my lord, that is a we are now, my lord, want to get report as because, my lord, some difficulties is DM is the authority, my lord.
Only he wants only his name to be included in
For
the
that
list.
is, my lord, there is some procedural matter, my lord. So they will consider and dispose of the
How much
same.
time you need?
Only 6 weeks, my lord.
6 weeks.
Yes, my lord. We will consider his aspect. After a long, my lord, that is past 2005, my lord, is the first. That is the then, my lord, 2007 DM. Now, my lord, 2012. So
Now he has made a prayer for appointment under the land loser scheme.
yes, my lord. First, my lord, there is a empanelment. After that,
What is AC? AC.
AC.
Page 16, he has addressed it to AC. What is AC? Oh, superintendent engineer.
Oh.
Public health engineering. So this was acquired for pump.
Yes, my lord, for this purpose.
For pump.
Yes, my lord. Superintending engineer, North Bengal Circle 2, my lord. PHA department.
no hearing, rejection.
My lord, in hearing, my lord, we must call him, my lord, as
Up to
in
you.
his presence. Otherwise, my lord.
Point, yes, it
Yes,
has
ma'am.
been, his name has been already recorded, or you,
Yes.
that will be recorded, you can do that. Unnecessarily, he need not be called for
Yes, my
hearing.
lord.
If you say no, he is not entitled to, then give an opportunity of hearing.
Yes, my lord.
That will simplify the process.
Yes, my lord.
Yes, next.
I am for the state, my lord.
I appear for the respondent number
To appear
225
on behalf of
KMDA.
the petitioner, my lord, this is my application. My lord, the predecessor in interest of the petitioner was
What is this? Acquisition.
no, your lordship, a feeder road is constructed. My lord, I relinquish my plot.
KMDA.
KMDA, my
Talukdar is creating all the problems.
No, no, I'm not creating. They are not complying with the.
Development, you are creating all these problems.
No,
My lord, they
the-
take my land, construct the feeder road. My lord, they give me permissive possession of an alternate land. My lord, thereafter they do not complete the process of allotment. And my lord, not
kindly,
they
kindly,
register the lease.
kindly come to page 44. They are not complying with the directions. Earlier, they came to before this honorable court, moved the writ petition.
Yes.
Direction was passed. Let me finish
Have
the.
to finish, sir. This is my application. May I make the submissions?
I am answering a query from the court. Pursuant to the direction passed by this honorable court, my lord, we took up the hearing. Petition was called up.
An order.
Yes, lordship,
But
page
page
44. Page
So
44,
that is
lordship.
under challenge in this writ petition.
That is not challenge. That has not been complied with. Page 44, lordship, that we require certain documents.
My lord, no
And-
allotment letter was ever made over to me. Now they call upon me, my lord, to hand over the original allotment letter. Your lordship kindly sees the order. My lord, page 45.
Page 45. No,
Yes.
what are you challenging now?
My lord, I am not challenging. My lord, my prayer is for issuance of the allotment
No, have
letter.
you challenged this order at page 45?
No, your lordship, because no decision was taken by this order.
No decision was taken. Let's
Yes, your lordship kindly sees. During course of hearing, my lord, the second paragraph, they have shown original papers regarding permissive possession and demarcation of land. However, from the official record, it has been ascertained that the concerned executive engineer that some hutments exist on the said plot. Further, it is found from the list of the affected structures along with the name of the owners, occupiers and tenants to construction of feeder road involved in RS Dag number such and such was purchased by Sri Anil De. This is my predecessor in interest. By deed such and such, this land affected by road. Official record has been perused. Submissions made by the incumbent has also been taken into consideration. Anil Kumar De died on such and such. His wife Kollani De also died. On going through the records, it is noted that there is no copy of allotment letter to Sri Anil Kumar De in the file. Also, there is no copy of possession advice issued by the office to them, save and except copy of permissive possession letter which could not be confirmed by the concerned sector. Applicants are directed to submit legal aid, succession certificate and also copies of allotment letter to substantiate their
So where is this document, that permissive possession and
Yes,
demarcation?
my
Where is
lord, may
that?
I show this to your lordship? This is at page, my lord, 26. My lord, this is a letter dated 28 November 2002. My lord, it says relinquish plot number such and such and notes the project. And thereafter, my lord, it notes that permissive possession was handed over. And the last line says final possession certificate will be issued on or after completion of other pending formalities.
What are the formalities? Mr. Talukdar, what are the formalities? Where is your decision of this meeting of the competent authority?
Decision on.
Yes, yes. Page 26. You refer to a decision of the competent authority. Where is that decision?
Competent authority, the decision is, my lord, since, my lord, this plot was
So show me the decision.
allotted.
Yes, yes. Show me this decision of the competent authority on the basis of which this letter was issued.
Just a minute.
Page 26.
Yes. It's a decision to allot an alternative plot.
There must be something on record.
Then I'll have to come with that. Certainly, there was a decision that in lieu of their
What are
land.
the formalities which were required to be completed by him?
My lord, here,
By her?
here,
Because
what
you said-
what we wanted.
Mr. Talukdar, three things are clear from this.
Yes.
There was a decision by the competent authority, and on the basis of that, permissive possession was given.
Permissive possession. The letter shows.
Yes. Letter shows.
Yes.
So you cannot come out of that.
No.
Next is this, according to you, this land as on that date was free from encumbrances. That is the second part. Third part, you said final possession certificate. So you have admittedly not issued any possession certificate, but you have given permissive possession.
Yes.
So you said certain formalities were pending. What are the formalities? First is the decision. Second is the formalities which that you have communicated him that he has to fulfill those. Please show me those.
My lord, here, Lordship will find the first paragraph, last line, within bracket pre-July 1978. My lord, there is a, my lord, seen that pre-July 1978. My lord, while
You
constructing.
are writing in 2002.
Yes.
And on that date, you have said free from all encumbrances. This is not in 1978.
No, decision. My lord is asking for the decision. Dear my lord, when during construction, many construction, many house, partly or fully, had to be demolished. So, after my lord, several negotiation with them, the authority took a decision to allot alternative land.
He cannot be landlocked.
We are not denying that.
So, if according to you, you cannot give him this, you have to give him an alternative one.
That has already been given. This is not the case. The plot was not given.
I am in permissive possession, but the final deed.
They have
is not
muted
being
it.
registered.
Lordship, kindly have a look.
Final deed.
Yes.
Mr.
Lordship-
Talukdar, you have given permissive possession.
Possession-
Give the final deed. What more is
They have mutated their name. Paragraph
As
A,
occupied.
7,
As
8.
Talukdar?
We are not denying. We have already
At
given.
times you are coming and saying mutation does not create title, and now you are saying mutation has been made.
Mutation. They're
Mutation has been given.
they are claiming in the
Alright, so
petition.
give the final allotment letter. What prevents you from giving that?
Paragraph 8. Kindly have a look.
My
Paragraph
lord,
8.
kindly sees the document at page 28. My lord,
Uh,
deeds have
Mr.
been
Talukdar,
recorded as occupiers.
What is the difficulty in issuing the final allotment letter?
Because for want of these documents,
What document?
that page 25, 45.
Yes.
45 or in the order that is indicated
No.
that we are not
legally a
having the
successor
petition.
certificate they can give.
Yes,
But
let them.
allotment, Mr. Talukdar, allotment letter they cannot give because from this document you have said that has not been issued. So if you have not issued, you cannot claim that.
We have not said that.
Yes. And copies of allotment letter to substantiate the claim as allottees.
If allotted, when this permissive possession was given, so there certainly
Mr. Talukdar, you have decided to give him the permissive possession.
We have
and
given that.
You have said final possession certificate. You have not issued. Show me that you have issued.
Yes.
Final possession.
Mr. Talukdar, you are wanting. You know very well that you have not issued something, and you want them to produce that. This is
no, my lord. Kindly. This plot was allotted in the name of Onil Kumar De. Onil Kumar De was the original allottee of this. Onil Kumar De died.
Now who has come?
His wife Kalyani De. The letter shown to your lordship.
Legal succession they will give. No difficulty.
It is for succession purpose only.
No. But yes, that they will give. But copies of the allotment letter they cannot give. If only one succession certificate they will give.
Why this was required by the authority?
Now you cannot require. Mr. Talukdar, you have not issued
because
something.
in 2002 it shows from that letter that 2002
Mr. Talukdar,
that permissive possession was given.
Have you allotted this to anyone else? No.
No. They are possessing.
What is the difficulty in issuing
They want mutation of their names in place of Kalyani De.
Kalyani De has come now.
Now, Onjude, mother died.
Thereafter, Kollani also died.
Original LOT was the father of the petitioner.
Right. Mother also died.
No,
Mother was, this is the daughter of this. Yes, daughter is now coming.
daughter,
My lord,
colony,
This is Onjude.
my lord, Onjude is the daughter
Yes.
and
So now
son.
daughter is coming.
daughter and son.
Yes.
Daughter and son. So they will be
One-
filing an affidavit.
Legally, let them file.
Yes. So allotment letter.
So why, my lord, let me explain
allotment
this.
letter you have not issued, Mr. Talukdar.
If issued, because in our record,
Show me that you have issued from your official records.
that,
When you have issued.
that is not available, we have recorded in our order.
So now it's in their possession.
If
have
it is
stated-
in their possession, let them produce.
What they will produce.
If allotment letter is issued,
Please, that will not be required. You have not. It's not your case that you have issued the allotment letter. You have not. You have not produced any document to show that you have issued the allotment letter.
Since-
you can
since-
claim something which you have not issued.
not issued, we cannot say.
Talukdar,
At present, we cannot say.
Said it has been mutated in their name.
They are claiming mutation. They have mutated.
Yes. Are you disputing that?
We are not disputing.
So are you disputing they are in possession in that plot?
No.
So issue the allotment letter. Nothing is
Let
required.
let them furnish legal heir certificate.
Yes, that yes.
But that affidavit we had already given, my lord. With
Affidavit
our
will not.
representation.
Affidavit.
Page 47.
Affidavit will do. For that legal heirs, what you want? You can also take an indemnity bond from
Yes,
them.
my lord. We shall furnish.
Take an indemnity bond.
We shall furnish.
Affidavit. Why legal heirs succession certificate?
Legal heir certificate they can
Why
they can
we have an
produce.
affidavit they are saying.
In addition to the affidavit,
Will-
they can obtain a legal heir
Talukdar, who
certificate.
will issue the legal heir certificate? Which authority?
My lord,
Which authority will issue the legal heir certificate? Please show me the provision of law. Which authority?
well, the local authority
do not
can local authority
Under what provision? Show me, not
provision.
individual.
Provision is not there.
Show me the then, Mr. Talukdar.
But
How
it
can
is
an
done.
authority act when the statute does not empower him to do something?
My lord has also come across in various cases. Below this is done. The local authority certifies that.
Show me the provision. If the provision does not empower, I cannot direct that. From a legal. So he is giving an affidavit.
My lord, I shall affirm again. Fresh
of the
affidavit.
Magistrate.
Lordship.
Let him do so. We will consider.
When can you?
And no other issue involved in
Give
this.
a magistrate's affidavit. Here and now, I will supply it to him, and he will issue the allotment
My
letter.
lord, kindly gives me 1 week's time. My lord.
Alright.
Let me come.
Ashun.
He is assisting you. Always.
Lord, may I be permitted to file the affidavit of service, my lord?
Great. I'm coming up. Yes.
Item number 1. Lord, I have taken instruction, my lord, from the client's daughter has is present before the
Yes.
court. He has given the instruction of a consultation with the client, my lord, to withdraw the matter. With the liberty to move.
After some argument,
My lord, item number 9, I am for the petitioner. My lord, service is not done. Kindly not this week.
service upon whom has not been done.
Look, all the points we kept open.
I
But
have
the-
withdrawn. I have not said anything on merits.
But
10-3 order was passed, my lord. After that, my lord, the encroacher filed an appeal on page 17.
Yes, yes. What is there? What is your ground? Where is the order, Mr. De?
That is, my lord, order is, my lord, starts from, that is 14, page 14, my lord. Starts from,
Page 14.
yes, my lord, that is the last order, my lord,
No, this is the order under 10.3.
10-3.
So he has
That
the
was-
right to prefer an appeal.
Yes, my lord, he filed the appeal.
Then what has been done?
That was
Appeal?
nothing, that he stated nothing, my lord. Or that
Has
is
he preferred an appeal or he has challenged this order in the
appeal. That is page,
to communicate the reasoned order?
yes,
Mr. They dispose of the appeal within a certain time.
yes, ma'am. We can dispose of that. ভালো করে।
Encroacher or he is the other person?
He is the encroacher.
I think he is Subir Hussain.
Sabir Hossain.
Sabir Hussain.
Sabir Hossain Mia, my lord. The appeal, my lord, Sabir Hossain Mia, respondent number 3, my lord. Sabir Hossain Mia, respondent number 3, appeal.
No, Sabir Hussain Mia is the
Respondent number 3.
Respondent number 3
in appeal, page 19, my lord.
Page 19. Oh, yes. So he has alleged he was the complainant.
Yes, my lord. Encroacher is filed appeal, my lord.
Encroacher has filed the appeal.
Yes, my lord. He will get that chance. That
so,
till has disposal.
So,
Yes, my lord, your lordship can. SDO passed the order in favor of the petitioner. My lord.
yes,
To
SDO
encroach
passed
the
the order. Now he wants, and they have preferred an appeal. He wants the appeal to be disposed of
within certain time.
Awesome.
I do not think I am for the petitioner. It is wrongly filed. It should be group 9 police in action. Page 26.
Police in action.
Page 26. This is the complaint for initiation of an FIR against the private individual for dilatory comments about the Hindu gods and goddess, hurting the Hindu sentiment.
Learned advocate appearing for the petition. Yes.
No, I'm for the petition. Deputy Service Matter. I am the member of the Atpara Somobai Krishi Unnayan Samiti, my lord.
Yes.
Page 13, my lord. Authority has issued their notice, my lord, for filing the nomination. Page 13, my lord.
Page 13.
Yeah, 13, my lord.
Yes.
My lord, dated, my lord, 1, my lord, মনোনয়ন পত্র বিলি 30/12/2025 সমিতি বেলা 2 p.m. Only paid for extension time, my lord. Only minimum 24 hours, my lord. To online. Oh, yes. Oh, sorry. Further, my lord, authority has issued the
What is this scan for? What is this?
Yes, can my lord, one of the my lord, addition of party, one of the party has not been made in the party's application, my lord.
Yes, sir.
Next, my lord, one of supplementary affidavit, my lord. Can take addition party হয় যেটা সার্ভিস তো করবে সার্ভিস করবেন তো can has not been served party
So then the copy to কারো আছে স্যার
এই দিকে একটা কথা মানে supplementary kindly see my lord authority has issued this notice further, my lord. This page 5, my lord.
Supplementary affidavit.
Yes, my lord.
That is the supplementary affidavit.
Supplementary kindly. Annexure P3, page 5, my lord. Next time, identically issued this notice, my lord. মনোনয়নপত্র বিলি 7/1/2026 10টা হইতে 2টো মাইল।
Yes.
মানে only pair, only minimum 24 hours, my lord, kindly.
24 hours.
Yes, my lord. And petitioners are all are cultivated cultivation in profession, my lord. Through online process.
Through
online process.
No, have you have not got the nomination?
No. Today is the collecting the economy.
Yes, what is the difficulty?
Well,
you could not go.
No, I go whenever some protection for the political issue.
You anticipated that when this writ petition was filed on you filed the supplementary affidavit when?
Yes, on 5th. 5th.
So you anticipated that you will not be able to go within 10 to 2.
Well, some political disturbance is made.
What political disturbances?
Opposite party. Kindly only.
Where is the allegation? So that may happen also for 24 hours also.
Yes. So kindly extension 24 hours. Not attend the.
Why you could not attend?
I could not attend the office of the nomination, collecting the nomination form. Some political disturbance. Some political disturbance.
What political disturbance?
Forcefully he has obstruction this collecting the nomination. Only PR, my lord.
Show me, we have made a complaint to the police.
Yes,
that
yes.
Where is that?
Through is it online? Today is complaint through speed post or courier service, my lord.
What? This nomination papers will be sent through courier service?
No. Complaint to the officer in charge, Jamalpur police station.
When have you lodged this complaint?
Today, my lord.
Today. So, when can you attend the office of the Samiti? At what time?
10:30. 10:30.
Today you cannot attend?
Yes.
Where are you now?
He is the residential house of the Atpara.
How far is the office of the Samiti?
3 kilometers.
Kilometers. So you go by 3 p.m. Now it is
difficulty is this.
12:38.
But I appear for the election commission. Now,
It is 1 hour more.
No, difficulty is this. In case 1 hour, then hundreds will be coming up, taking in instance. Kindly appreciate the situation. Now,
I'm not extending. I'm not extending.
No, 3,429 voters.
Yes.
Now, my lord, initially, the election program was announced and it was scheduled to be conducted on, my lord, 12th of December 25. Then, my lord, difficulties was shown, and my lord, more than 300 people of the voters of the locality, they made representation stating their, my lord, problems. So it was announced first. 12 election. Before that, my lord, all programs were announced. Nomination remaining same. Who have collected, not collected. Then, my lord, what happened, my lord, considering the demand?
Earlier, that was also distributed.
Yes. It was always open. Kindly appreciate one thing. What kind of attitude? Because then, at the sweet will of a person, if election program is deferred or time is extended, then, my lord, election can never be, my lord.
Ask your client to attend within 2 p.m. He can attend.
No, my lord.
Yes, mention is 2 p.m.
Also kindly appreciate. Now, my lord,
No,
then,
time is still 2 p.m.
then, my lord, no, nomination paper will have to submit it. Today, the program is there, my lord. Kindly come to their.
No, nomination paper will be submitted
next day.
10 to 2 by tomorrow. So he wants to collect the nomination paper.
Yes.
He will attend your office within 2 p.m.
Yes, in that permit, there is
kindly only PR, some protection, Malan.
What some protection?
In any disturb, Malan.
What?
To collect the nomination form.
Wait.
To collect the nomination form.
144 order is asking for, my lord. Let him go approach and
action. Approach the police in action.
I complain the officer in charge, Malan.
If there is any inaction on the part of the police, that cannot be granted.
And this is the second time, lordship.
Seems that you are not interested in collecting the nomination paper. You are only interested to stall the election.
No, my lord. No, my lord.
Please ask your client to go within 2. I'm keeping it at 2 p.m.
No, my lord, he is very long distance, my lord.
Then nothing can be done. I'm keeping
My
it
lord, only 3 p.m. he is submitting.
I'm keeping it at 2 p.m. Ask your client to go within 2 p.m.
No, my lord, he is long distance, my lord, kindly. By 80
kilometers, how much time it
No, my lord.
You said 3 kilometers.
3 kilometers from Atpara Samabhay Samiti.
That I do not know. If not, you will not be allowed to collect the nomination papers. Choice is yours.
And this is second time, lordship. Then again,
earlier there was a date.
Yes.
Well, I'm admitting, my lord. I have supplementary. I submit.
So it was sufficient, but and you could anticipate that you will be on 5th. You could anticipate that somebody will obstruct
will be restrained
from 10 to 2.
Yes, my lord. Only PR, my lord.
No, you anticipated that you will be obstructed.
No,
obstruction is known to you.
No, my lord.
Sir, I'm keeping it at 2 p.m. Ask your client to go and collect the nomination papers by 2 p.m.
Or lordship can dispose of the matter directing this. We shall intimate if somebody comes.
Kindly direct,
No. Let me see. I'm keeping it at 2 p.m.
No, my lord, kindly direct to 2 p.m. Submitting the 2 p.m. Collecting the nomination form.
2 p.m. if you attend because the time is still 2 p.m. Ask him to go. I'm keeping it at 2 p.m.
No, my lord, 80 kilometers from distance from that. Kindly dispose this matter.
That cannot be done. I'm keeping it at 2 p.m. Ask your client.
Make some observation, fix it tomorrow, lordship, then we can communicate. The result will be communicated to your lordship tomorrow morning.
What publication?
No, tomorrow problem, the result, what exactly happened.
Also take instruction from our
We shall also take instruction whether he approached or not.
If he has not, he will instruct, and you also instruct your officers.
No, that
by 2 p.m. he attends, he will get. Ask your client to attend by 2
kindly tomorrow, my lord. Tomorrow 10:30.
Matter may be fixed up, but you want to approach by this
You have
time.
to approach, otherwise I will not
No, no, no.
extend.
Yes, my lord. Yes.
2 p.m. I am keeping, ask your client, then keep it, otherwise no use keeping it to tomorrow.
My
If
lord's
client does not
my-
attend, then it's end.
My lord's observation will suffice.
Does not attend today, it's end of the matter.
Yes.
So that is why I am giving you time till 2
No,
p.m.
my lord, kindly dispose this matter, my lord. Kindly.
2 p.m. come at
No,
2 p.m.
he has not attained this court, my lord, 80 kilometers from it.
All right, come at 2 p.m. I will pass orders at 2 p.m.
But
Yes,
it,
for the next matter.
But not make it 10. So I will be in difficulty.
Ask your junior to appeal. This is your
There will
submission.
be here.
No, no, I'm not a
Yes,
second register.
for the next matter.
Milord, in this matter, Milord, I am for petitioner, Milord.
Yes.
Milord, kindly see the order dated 2nd of January of this month, Milord. 2nd of January.
The Lordship added WBIDC, the requiring body, as a party.
Milord, I have complied with the order passed by your lordship.
Yes, Mr. Bharat.
My lord, kindly, my lord, more times, my lord, times is required, my lord, more times is required because, my lord, we assess, my lord, whether, my lord, is what is we have paid the state or not, my lord. Kindly, my lord, 10 days time, my lord.
All right, Mr. Banerjee, you pay, you realize. Because if he has paid to you,
No, he has
claim
not paid. We have asked for the money.
He says he has to ascertain from his office whether he has paid it to you. You pay it to him. If he has paid it to you, you cannot claim.
was paying
Not
for
paid, you realize.
We have to pay. Ultimately, it's responsibility of
That
state.
is why.
I was paying for a corresponding direction upon the IDC Miller to pay the amount. Because ultimately, unless what will happen if they don't pay Miller? If they don't pay Miller, what shall be the alternate?
Yes.
What is the correspondent with this?
Because they are utilizing the land.
All right, I'm keeping it on 14th. Take all instructions, whether you have paid, whether you have not paid, when you will be paying.
Milord, in the meantime, direct to pay me, Milord.
To whom? Can you not wait till 1 week?
Lord, let me not. The land has been Lord requisition Lord under 318. But Lord, no 418 notice was there.
Yes, who is for the state?
Lord, Supratim Dhar.
Yes.
The learned advocate Supratim Dhar.
Where is he? Where is he? What is your name?
My name is Siddhartha Kundu.
Use the microphone.
My name is Siddhartha Kundu, my lord.
Yes. Where is Mr. Supratim Dhar?
I have not.
Yes, Mr. Dhar, you are not appearing in matters. Your matters are being called on.
This is the matter. First time I believe
Yes,
in this.
not appearing.
And I was.
You are roaming outside.
No.
It's cold outside.
Feel. Koi. Asini.
Yes.
Judgment.
Yes.
NHA? Huge exception in this matter, my lord. I also used exception.
Exceptions to the report. What is the report? What does the report say?
Delay is there.
এতবার বললাম তো
Oh,
আপনাদের
delay.
Delay.
Yes, Mr. Dhar. Please start. with the judgments you have referred to in a matter in which you appeared for the petitioner. Start from there, then proceed with the other judgments.
Report, proceeding, my lord. I only lawyer kind absence, my lord. The report, my lord. Report, my lord. The
Please
report.
take your seat. Let Mr. Yes.
এই দুটো কই এটা কই এই জাজমেন্টটা কই
Yes, where is that judgment in the KMDA matter, Cosma property?
I'm having mine.
Where there was no existence of any plot.
Yes.
I think I'm right. You appeared in that matter.
Yes, yes.
Stay point was
আমি
taken.
দিচ্ছি সব আপনার ফেভারে জাজমেন্ট দিয়ে দেবো আপনি চিন্তা নেই
Yes, this is that matter.
And in that matter, state has gone up to the appeal court. Appeal court has dismissed the appeal by saying that you pay the compensation. There, the factual scenario was no acquisition whatsoever.
No, I'm on the delay. Then I will come to the facts.
That is on the point of delay. Delay has been threadbarely discussed, and two Supreme Court judgments were relied. That is Tukaram Joshi, and the other one is Vidya Devi.
Yes.
That is 22, volume 2 SCC 569, which is at page para 9. And my lord has relied that while considering the question of delay. Now, my lord, kindly come to para 23 and 24.
Yes.
And Vidya Devi was also relied by my lord.
Yes.
And Digambor and Bandha Development Authority and Nanda Rai has been discussed, and so this got merged with the Honorable Division Bench judgment. Now, my lord, I would be
March means delay point also decided by the
Yes,
judge.
yes.
Please give me that.
No, that judgment I do not have, my lord, at this moment, my lord.
Give me the appeal number.
No.
একটু বার করুন তো অ্যাপিলের জাজমেন্টে ওখান থেকে প্লিজ গিভ মি দ্য
এটা
particulars of the
এইটার অ্যাপিল হয়েছিল The Honorable Division Bench did
on the
not
ground of
discuss.
delay- on the ground of delay any finding is there.
Just appeal is dismissed
All right. Yes. This was an appeal by the KMD or the
by the KMDA. State has accepted in that judgment while doing the inquiry in presence of the
was on facts.
that was on the facts. No, state
On the delay.
special LAO had also requested the KMDA in that case that since you have not done the acquisition proceedings.
On the ground of delay, I'm saying.
No, state has not preferred that.
Yes.
Appeal number now.
Number of the appeal.
No, I'm trying, my lord.
Yes.
And my lord, এই জাজমেন্টটা দেখি সাধন নারায়ণ
Appeared for the state in that matter. You must be knowing the number of the appeal.
আরে সুস্মিতা গোয়েন জগন্নাথ যশোরা
You appeared for the
Before-
state in that matter. You must be knowing the number of the appeal. Yes, yes. Now
No, I'm supplying that one. Then এটা দিন না সবকটা জাজমেন্ট
this is what?
This is the judgment on considering all previous division bench, not all, one of the previous division bench judgment, that is Mohadev Khan, which was
Ground of delay. No, this is on merits or on the ground of delay.
this is only on merits.
Merits. Yes, merits. Make your submissions. What is that? Thereafter, I will take the decisions. Yes. Make your submission first. Thereafter, I will come to the. What is your stand? It was a requisition under Act
Only requisition. Thereafter, no 4-1A.
2013 Act,
No, there is a direct purchase policy.
subject to his acceptance. Purchase is contract, Mr. Thor. Mr. Thor, the expression purchase means a contract. There has to be an offer as well as acceptance. It cannot be one-sided one. You cannot force the direct purchase policy because you have incorporated the expression purchase. It's an offer and acceptance. You may make an offer, they may not accept. If they accept, well and good. Are you accepting purchase policy?
We have denied. We have denied in the requisition law.
You are not agreeable to the direct purchase policy. Yes, you not agree. Then 2013. What has been said in now? Now kindly come to this judgment. What it has been said?
That is the judgment.
I have also delivered a judgment on this. Where is that?
No, that I'm not having one at this moment.
Petitioner's advocate was the same advocate.
This judgment has also discussed about Niladri Chatterjee.
I have also taken care of Niladri Chatterjee.
Only sole judgment in favor of the state.
Yes, Niladri Chatterjee I have also considered.
And thereafter, this judgment has said that proceedings got lapsed. The factual scenario in this.
I also considered another division bench judgment subsequently.
Which says?
That was also subsequent to Niladri Chatterjee.
Initially, Justice Arijit Banerjee, sitting in a division bench, passed an order. And thereafter, my Lord Justice Arijit Banerjee has criticized that previous judgment.
No, passed what order?
That at the old rate, he will get the compensation. Then subsequently.
No, sir, previous as well as the subsequent division bench judgments are there.
Yes.
Because once everything lapses, then
this.
If you have utilized.
Well, kindly go through this judgment. Well, this judgment is factual scenario is after 3-1, then 4-1A. Then 4-1A. Vesting is there under subsection 2 of section 4. Vesting is there. That once 4-1A notification has been issued, the land vests. Then, if in terms of 7A, if the award is not made, then it lapsed. The entire scenario gets changed. It revived. Then this judgment has also taken into consideration about the 9-3A and ultimately has held.
Considered that in a KMDA matter, where the learned advocate general appeared for the case.
Oh.
Similar facts. There the issue of once vesting.
Cannot be divested.
I've also considered that aspect.
That was the point taken by Honorable by the learned Advocate General before Honorable Justice Harish Tandon, sitting singly, and Justice Tandon has deprecated that submission and challenging that order. The state went up to the appeal court, and this judgment, Mahadev Khan judgment, was passed by the Honorable Division Bench. This has been relied in this judgment.
Yes,
that is.
So in that matter, the learned advocate general appeared for the KMDA.
In this matter.
He referred to the Indore development judgment.
And Digambar.
Which dealt with once vested cannot be
divested.
So he specifically relied upon that. I considered that.
I
delivered a judgment. 2 appeals were preferred. One by the KMDA, other by the state, both dismissed.
Okay, may I get the name at least?
Where is Mr. Amit Kumar Pan?
Oh, in Mr. Pan's matter?
I think so.
Oh. Well, I'll get that.
Mr. Pan's matter. So you are also taking this here. What is it? 4-1 has been done? No. Then it's on a better case. So requisition.
Only requisition.
So there is no vesting. We did
No,
not
not at all.
So we did not go that far. So requisition after the expiry of the lifetime of 48 Act, gone.
I do not have a
And
case.
utilized.
And utilized. I have supplied all the judgments which was against me in that judgment.
Where?
This Sadhan Narayan Kundu.
Yes.
Only Niladri Chatterjee I had relied. And then Mahadev Khan. As my lord has on the last occasion has said, the change of status, I should not hide any judgment.
Yes, yes.
Yes. I still can recollect. And
So here the division bench so in Sushmita Gwin delay point was not argued.
not argued.
Only on merits.
Only on merits.
Supposes the state did not challenge the issue of the ground of limitation. So that was KMD's appeal.
Yes.
All right. Be that as with same thing. And can be said to be the state's appeal because the learned advocate general appeared for the case.
And that is the law. I can't deny. I may hear something here from there that I should not submit this kind of judgments or all the judgments, but
What is your stand in the report in the form of an
the report says
only on the ground of
only on the ground of delay.
where?
Page 13 of the report can be seen.
What does it say?
Huh?
Yes.
Thou?
They are all available.
Page 13, yes.
One of them is 8th of May 2018.
18th of May 2018, yes.
This says
Requested after judgment.
concession. They have stated everything in this.
All facts have been stated here.
All stated in lot. There is no Purvane, only 3 was there, 3-1 was there. 500 ticket compensation, but as the recurring
Facts have been stated here. Requisition T1. Then
14, page 14.
have been taken over and delivered. Notification has not been published. Admitted.
Dilip Ghosh's actor.
No award has been prepared and payment has not been made. So requisition.
Mahadev Khan's matter.
Second paragraph.
Who is the requiring body?
No.
Mr. Dhar, who is the requiring body?
PWD.
Paragraph 2
Everything is in his favor in this judgment. In this order, the impugned order.
I have seen that. We have admitted that
entitled to have compensation.
Yes, only it says
first paragraph. Lapse case has been ineffective upon decision of Sadarsa Act 1 as a result of new Act 2013, which is applicable from 1st of January 2014, but no rule has been yet been framed by the state government. This is their point on that point. They have refused. They have not paid the compensation.
the other judgment my lord has passed, sitting singly, that is 3-1, then 4-1A, then 9-3A was not issued.
Yes, I think no. Here
No, that is not. KMDA is not involved. That is perhaps
KMDA's matter. This vesting issue was raised.
Yes.
Yes, Ganesh Samanto.
Ganesh Samanto was relied. Ganesh Samanto was relied.
Ganesh Samanto. That's the division bench judgment.
Yes.
Yes, Ganesh Samanto, I relied upon that.
Where learned Advocate General,
Milati Chatterjee also has I have considered.
where learned Advocate General was appearing on behalf of the
That
land
was on
loser
the basis
claimant.
of an admission made by one of the parties, Milati Chatterjee. It's not a precedent.
And Ganesh Samanto was passed by sitting in division bench by Honorable Justice Jyotirmay Bhattacharya. And where the learned Advocate General was appearing on behalf of the land loser claimant.
And Ajiman Bibi is which judgment?
Ajiman Bibi, well, even in the previous judgment, have Ajiman Bibi is under Development and Planning Act.
There also, I think, after this lapse of that, it has been stated. Because
Considered by the land development by the recent judgment was passed by division bench, our division. Considering the Ajmal Bibi and others. That's
Mahadev Khan, Dilip Ghosh, Jamaluddin, several judgments. জামালউদ্দিনের একটা সেট দাও না।
requiring body is the party
Where?
in this matter. Yes, who is representing the requiring body? Not the state.
My lord wants to. Yes. 6-7. Keeping in the mind of UP Jal Nigam principles.
What?
That requiring body. My lord, oh.
I'm only
দিলীপ ঘোষের আরেকটা জাজমেন্ট দেবে?
Mr. Dhar, what is this decision in under challenge? No finding. What is the finding here? It was not rejected.
No, I found the legitimate of that order.
No, this order is
পেজ কত? ইমপিউন অর্ডারটা কোথায়?
no. Please kindly come to your report.
Oh.
Your report, page 12. You have annexed this.
দেবে? নেই। দেখি রিপোর্টটা দেখি।
Page 12. Please kindly come to page 14.
Yes. It is referring paragraph number.
The entire order is
Yes.
in favor. At the current market price and make payment. In another matter, does the petitioner's request duly considered and disposed of? What is the decision? How it was disposed of?
Only referring a previous judgment. That's it.
Yes.
In that case, Lord Justice, Lord Ashok Dalodiri, as his lordship then was, he directed to pay the same. As such, they have paid the same on the basis of Lord. Considering
Now you have sought for an estimate from the direct land purchase committee.
I have challenged.
But if he does not agree, Mr. Dhar, then what is to be done?
purchase is a contract. I cannot. Until unless I invoke the principle of eminent domain, that there I can bound the other side. But when it is a purchase, it's a willing buyer, willing seller. That principle is applied. I cannot force
He
people.
does not accept your offer, you accept his offer. Purchase at his rate. He will quote the rate, take it at that rate.
I have annexed one.
Even in respect of market value, the same principle, Supreme Court has time and again said, it's a principle of as if a willing buyer and willing seller.
Market price has to be that. That is why that's the concept of market price. That's the concept of market price because whatever way, now we have given a new name, but you cannot force him to purchase at your price. If it gives another, accept his rate, pay it at his rate. Because you are willing to purchase.
Difficulties.
Now it's the
which date would be the factor to be taken into for market value. If there is no 4.1a, because 4.2 says
comes to purchase, Mr. Dhar, who will fix the price? Purchaser or the seller? What's the concept of purchase? Even if we accept, who determines the price, Mr. Dhar?
obviously seller.
I give him liberty to quote his price, accept that.
I have annexed
Because you are willing to purchase.
I have annexed to deed.
You have utilized. You are bound to purchase. He will quote the figure, accept that, pay that. Because you want to purchase that. That's your offer. That's your ultimate memo. But not at your price. Because he is the seller, he will fix the price.
Kindly keep it in mind that this property has been utilized for the purpose of benefit of the citizen of this state.
At the cost of, you will understand when your property is taken.
My lord has to strike a balance.
Cost of,
well, my lord has to strike a balance at least.
Cost of, I am saying. After all, you are the state. You have to look after the citizens. Something plus minus, you can also agree to that. May not be much of difference, which the price you will be fixing and they will be claiming. Pay at that rate. Something plus you are the state. After all, have to look after the benefit of the citizens in that way also. So the petitioner is also a citizen. You have to look after his benefit also.
Let me come back with the price then. If
what is according to you, what should be the price? Have you taken instructions? Mr. Bhattacharyji, have you taken instructions? What? How much your client?
Decimal 2 lakhs. Decimal 2 lakhs. I have
decimals 2 lakhs.
2 lakhs. I have annexed.
So what should be the how many decimals?
কোথায় লেখা আছে?
What is according to you? What should be the price?
More than 2 lakhs. Now, my lord, I have.
What should be the total amount?
Total amount, Lord, in this Lord, that is 58 lakhs. 58 lakhs.
58 lakhs. And
more or less.
More or less. Mr. Dhar, what is your instruction with regard to it?
Well, I'll have to take the instruction on that.
Please come with the instructions if this can be sorted out.
Well,
I think it's
well,
he is saying please take instructions and
my instruction is going to market. Next matter.
What is the market value? That is what I am asking you. Market value is a very vague term. What is the market value according to you?
Adjusted land, my lord. Yes. Adjusted land purchase within it.
What is the amount?
জেনে বলছেন না তো আগে
Ascertain the amount. He will take instructions if that can be done. Otherwise, this litigation will go on.
Support of this, my lord, I have understood it, my lord,
Please take instructions. What is your claim? Let Mr. Dhar also inform Mr. Dhar. He can also take instructions on that. So if it is agreed upon something, yes.
58 lakhs, because 29 decimal is there. If it is 2 lakhs.
একটু লিখে নাও, please.
Mr. Dhar, please take instructions. What should be the amount so that
29 decimals at the price of 50 lakh, 58 lakh.
yes, at the
Yes.
2 lakhs per decimals according to you. It's take instructions. What should be something plus minus here there. It can be otherwise. This will.
Malad.
Yes. Heard the
My claim.
I cannot decide on the market value. If you agree upon the market value, all right. Otherwise, I will be deciding on merits. Then you fight it out in another forum. If something can be agreed upon, plus minus something here and there, then it can be decided. Otherwise, whether the market price is 2 lakhs or 1 lakh 50 or 3 lakhs.
We are not willing because we got when Milord.
I'm not asking you why you are not willing. If you say you are not willing, I will dispose it of in merits.
Well, let Milord. I am not willing. I have stated in the written decision.
আরে তাতে তো আপনার
Alright, then I
ক্ষতি
will.
হবে।
Then Mr.
তাতে তো
Dhar, then
আপনার ক্ষতি হবে। আপনি আরো লিটিগেশন চাইছেন?
this will not end here. I'm telling you. That is why. So please take instructions. এতে রাখুন তো এই জাজমেন্ট গুলো। You also give your estimate whether you are willing, you are not willing, what price.
আসবে কি
Next is also same.
আর
Yes, call the next matter.
Your Lordship, in item number 15, I appear for the state respondent on the led by Mr. Debabrata Banerjee. On the last occasion,
Who
Your
is for the petitioner?
Lordship, we are for the petitioner. We are led by Mrs. Usha Maiti.
Your Lordship, on the last occasion, Your Lordship had directed us to file in the form of an affidavit whether the award has been paid.
Yes, yes. Where is that?
Your Lordship, today itself, I've just got the thing. So just kindly give me some time so that I can prepare it. The award has been paid. I've got the list of awardees.
The amount paid?
Yes.
No. My prayer was before Your Lordship. My land is 33.5. They have acquired, but only 22 decibels for compensation is paid.
1 week time.
1 week.
On the prayer of the learned. Yes.
Lord, item number 16, Lord, I approve the statement led by Mr. Lord Mahatma. Lord, last occasion, Your Lordship directed the state law advocate to take instruction from the assistant engineer Diamond Harbour. My Lord, last occasion, Your Lordship directed the state advocate to take instruction from the assistant engineer Diamond Harbour subdivision.
Yes, yes.
My lord, we tried our level best by over telephone, my lord, but they, my lord, told my lord that copy has yet not been received by them. So they are.
You have got a copy. Why
Yes,
couldn't
I
you
have.
forward it to this a copy of that?
So my lord,
You have been served with a copy. This is neither here nor there. This is neither here nor there. Have you served? Where is the?
Well, every service is there.
Yes, served.
So my lord,
And you have been served.
I have.
The authorities could have collected it from you.
Lord, matter is not Lord unauthorized allegation of unauthorized
Sir,
construction
we made a
over the
representation,
PWD
let
land.
the dispose of directing the
After demarcation, it let the matter be disposed of, my lord.
Assistant engineer.
Yes, my lord.
assistant engineer.
Page, my lord,
Respondent.
14.
Response number 6.
Page 14 is the
Private respondent has been implemented.
Yes, my lord, sir, they have received. Every service is there. In front of my shop room, my lord, is the priority road.
Claims to be the petitioner claims to be the
Obligation of encroachment. In the representation, obstruct the other stall is.
On PWP road, yes, said, if there is no encroachment, Mr. Mahato, you have a duty to see if there is any encroachment. You should not go into the technicalities of those representations. You know who drafts those. Yes.
My lord, I am for the petitioner.
Lordship, I am for the union.
Respondent number 1, Union of India.
I am for the Union of India, Lordship. I'm
Kindly
leading
come
her.
to page 145.
Yes.
145, my lord, this is the third round of litigation. 145 was page number 145.
Yes.
My lord, this is the order passed by this honorable court, basis of which my matter, my case has been referred to the appropriate authority for redetermination of the compensation amount.
Lordship, on the last occasion, I had sought time to seek instructions, Your Lordship. I am appearing for the Union Railways.
This is railways.
Yes,
Yes.
Lordship.
Yes, Your Lordship. Arbitrator was appointed under section 20F, Your Lordship.
Yes. Arbitrator has passed an award.
Yes, Lordship.
Yes, Your Lordship.
Then you have to challenge under section 34. But the arbitrator has given his award. How can you challenge in a writ petition?
149, kindly consider. Page
149, yes.
And my prayer is reconsideration only. Arbitrator reconsideration because
cannot be done. If an arbitrator has been appointed, all the provisions of the arbitration and
may I
conciliation
submit? May I
shall,
submit?
shall apply.
May I submit? My lord, first award was granted.
Come at 2 p.m. The writ petition is maintainable in view of section 34 of the arbitration and conciliation.
Number
11.
Yes, where is the
11.
11.
My lord, I don't think, Lord, he has any interest because conduct doesn't prove his bona fide.
Yes, sir.
Yes, sir.
Oh,
Right.
Malar, I'm called the petitioner, Malar. I instructed from my plan, Malar, not pressing this application, Malar.
not pressing?
Mm.
Yes.
Yes.
After some argument, the learned advocate
Similarly, my lord, normally in earlier practices, my lord, not every day matters are being fixed. In one day, matter any day is fixed, either Friday or say Thursday, according to convenience of honorable court. This is happening. If my lord so things fit and proper,
yes.
kindly accommodate in that way, then my lord, we may not disturb my lord, trouble your lordship.
So Nayak, only one thing, I am following a procedure,
Lordship.
the date of present in the presentation form, the date of enlistment, when it is mentioned, it appears. That's the regular practice in my
Lordship.
in all matters. So whenever what is the date given in the presentation form, either group
That is
1
being
or
followed.
group 5 matters are appearing.
Very well, lordship, this is our earnest request. If lordship feels similar, it is convenient for everybody and it can be accommodated, my lord, think
On a
in that.
particular day.
In a particular, property matters in one day, any day, any.
Your lordship,
But every day it is being taken up. You have difficulty.
No. Normally that would be helpful.
Your lordship, it is not.
Every day this property, I think yesterday it was taken up.
One.
It was said that wrongly it is appearing.
Yes,
it was scheduled to appear on 8th.
Right.
So I've adjourned to
Lordship,
also this matter as only in the presentation from the date, on that date itself it's appearing every day.
It would be convenient for everybody so far as our past experience goes, because especially we are doing this
One day
matter
is
one day, any day, any one day.
But what will happen if the petitioners come and say, I'm giving that date?
That can be
I can
mentioned.
fix any day. I do not have any problem. But if anyone comes and says, let us suppose we are
Suppose lordship, matter is fixed according presentation form Tuesday. Matter is appearing on Tuesday. But your lordship has been pleased to me, lord, to feel it convenient to fix court matter on Wednesday.
Yes.
So this can be accommodated for Wednesday, one day deferred, or Thursday, 2 days deferred.
do not have any difficulty. Let us suppose that I'm fixing on Wednesdays for these group 5 matters. But somebody files.
If any
on the
urgency,
date-
who shall appear?
They mention your
lordship.
lordship. Your lordship, what happens is most of the persons who are the petitioners, they are also engaged in cooperative tribunal. I am also appearing for registrar, your lordship. I usually appear for the registrar of cooperatives. What happens is there are certain matters which go, there is an appellate forum, which is at the cooperative tribunal. So at times we have to appear there. The court takes up the matter generally from 11 to 1. So, your lordship, the petitioners who are also before your lordship, at times the advocates come from the cooperative background, also gets engaged in the cooperative tribunals. Your lordship, so in that
No,
case,
I do not have any difficulty in fixing a date. Then you also do one thing. You in the presentation form mention that particular day in the presentation form. That's the end of the matter.
No, very true, lordship, but all are not here. We are the opposite party responding. Lordship, very well.
Tell them.
Lordship.
So I tell
Lord,
me
let us proceed in this way, my lord.
Tell me which date will be convenient.
any Thursday, Friday. No. At least we are making a submission, your lordship. It is up to
Which
your
day
lordship.
will be convenient?
Any second half of Friday, Thursday, Tuesday, any day which is convenient to your lordship. And in other matters, what happens is if there is an urgency, people come and mention before your lordship that I have some urgency, that is mentioned, and any day your lordship takes up the matter irrespective of the regular course, your lordship.
কাজ করে দিন
Your lordship can take 2 days also. Tuesday, Friday.
But it would be convenient if you tell your friends that in the presentation form to
Lordship,
specify the
obviously.
date of Tuesday.
No, within a week, it will be intimated to everybody.
Everyone will come to know, and
Hey, that will come to know.
So that
Very limited numbers they will use to practice in this melody cooperative matter. They will.
the second half ta na group 5 ta Tuesday 2 p.m. ta kore rakho.
Oh, grateful, Lordship.
so grateful, so grateful.
Yes.
Item number, monthly item number 119.
Yes, who is appearing? Yes, who is appearing for the state? Look, mentioned on the ground upgradation, on the ground of urgency, no one is appearing now. Mentioned, upgraded, no one is appearing. Who is appearing for the state? Mr. Dev, you are appearing in the earlier round of litigation, you appeared.
119.
119 of the monthly list. None appears for the
My lord, there are two ABW services. One is for service, copy service, another for upgradation notice.
upgradation notice you have served.
No, now, national highway,
On the national
the
highway.
national highways as well as state authority.
State who is appearing?
Mr. Shantimay Bhattacharya. Led by
Where is
Mr.
he?
Supratim Bhattacharya. Supratim Dhaur. My lord, urgency is my lord, recent notification has been issued by the national highways directing to remove all structure within 7 days from 26 December.
Yes.
But they did not pay the entire consideration amount, that is awarded amount. 50% of the awarded amount has been paid, 50% not paid. At this juncture, they are saying you remove everything, but rest amount has not been paid. Only direction upon the concerned authorities pay the entire amount and remove everything. We have no objection.
Removal, where is the national?
Kindly 3H of the National Highways Act. The amount determined under section 3G, may I read it, my lord? 3H.
No, 3D declaration has been published. Mr. Das, upon publication of that declaration, it stood vested.
Vested, but
So if it is vested, you do not have any right to occupy. Your prayer is to get compensation. That's a different thing altogether.
That is
3D, this is a different from the Land Acquisition Act. Land Acquisition Act, after payment, after award, vesting. Here, upon declaration, this vesting comes.
Well, 3H says
has been Act 2 of 1948.
This is my kindly concept 3H for a moment.
3H is payment of compensation, no dispute with regard to that. But vesting is 3D,
Yes.
2
3D2.
upon publication.
I have no objection, my lord. It is invested, but suppose removal of
No, no,
structure is there.
payment,
The awarded amount should be paid. Only 50% of the amount has been paid. It is not.
no, is it your case that the amount, no, it's not payment to you. 3H1.
Payment to competent authority.
Yes.
Yes,
So
but
is it your case? It has not been deposited before the competent authority. Show me that affirmation.
that I do not know. I have
Then,
only 50% of this, my lord.
then
It is
so
said before after
3H1
yes,
says that it's the determined
to
shall be
3G
deposited by the central government
in such a manner as may be
Yes.
laid down by
with the competent authority.
yes, competent authority before
Show me
taking
your case
position.
that you have stated that it has not been deposited by the central government with the competent authority.
Probably deposited, my lord. I am not on the probably deposited, but
Then
I have
if
not
the
received it.
government has deposited, possession can be taken.
I have not received it, my lord. 50% of this has been paid to me.
But who is appearing?
As soon as maybe alter the amount has been no, there's a question of alteration.
No, this is payment. This is payment. For that, whether this taking of possession can be. Yes, who is appearing for the national highway? Have you given a notice?
I have served upon the authorities, but who is appearing for
Authority,
this, my
some
lord?
advocate is, I think Miss Monica Rai appears. Yes.
Then, madam, I'm going to submit.
Please, I'm passing it over. Ask her to come.
Let money কবে আসবে জানো?
তুমি আমার নাম্বারটা নিয়ে নাও
Tomorrow, my lord.
None appears. The learned advocate for the petitioner is present. She is in VC. ফাইলটা দেখি। Yes, who is appearing for the state?
Mr. Shantima Bhattacharya, but
Mr. De, what is happening? The advocates who have been briefed, they are not appearing. What can be done?
আমাকে দিয়ে দাও কোন ডিস্ট্রিক্ট
Or the state have to go unrepresented.
দাও যদি পারি কালকে নেবো মাইলট টুমরো ইওর লর্ডশিপ ফিক্স মাইলট আই ক্যান whether money was deposited or not otherwise your lordship তুমি মনিকাকে দাও না মনিকাকে দাও এখানে না থাকলে আমার কোনো ব্যাপার না।
Yes. You are appearing. All urgency at the time of mentioning Mr. De.
Yes, my lord.
Thereafter, no urgency. This matter was mentioned by the learned Yes. What is your instruction?
Instruction is with Mr. Amit Gupta, who is the senior in this matter.
Yes.
Instruction with Mr. Amit Gupta. I've already informed him. The report is filed by the concerned police station Kulti in this matter. So far as my instruction.
Same order. This is for default. Next.
My name be
The state is represented by Islamic. Yes. Next.
I'm for the petitioner, my lord.
Yes, yes.
This is my affidavit service, and over phone I have already intimated the advocate, Mr. Tapan Mukherjee, Mr. Tapan Mukherjee, I have already intimated over telephone about the matter.
Yes, what is this matter?
My lord, my affidavit, my property has been utilized in every year for the purpose of construction of road for the purpose of Gangasagar Mela, to entering the jetty, temporary jetty.
For public purpose.
For public purpose, my lord,
For a
but
temporary period.
for a temporary, but in the meantime, my ingress and egress are disrupting. I have a prevailing injunction order. Every year they are seeking permission before the trial court under section 151. They but
This year also they have
this
opted.
year also this is the
Then what can be done?
my only intention is this is the this year's order, my lord.
Civil suit is pending and order has
Pending
been passed
and
by the
my
civil
lord, I am
court.
being led by Mr. Mukherjee.
Take your seat, take your seat. Yes.
My only intention is that I have made representation that property should be acquired in the proper way by initiating a proper acquisition process.
The civil suit pending.
Civil suit pending.
Yes, Mr. Mukherjee.
Yes. Kindly see the ploy. I have purchased a property not by investing crores of rupees. Not after purchase, I find that some portion I have mentioned in my representation. To what extent? Some portion of my land wherein I have made fencing, I have rooted the valuable trees, those has been uprooted, and for a temporary road is being constructed, not a metal road. Those portion has been used for a temporary use for the purpose of going to jetty number 5. It's a temporary jetty constructed for the purpose of holding Gangasagar Mela. This happened in 2022. First time after my purchase. This illegal trespass when happened, I immediately filed writ petition. This honorable court said, very well, there are something civil element is involved, you go before the civil court. There are criminal proceeding pending.
No,
I approach the civil court.
Against the private parties.
No, against the state. But I shall go take your lordship everything. I just give your lordship the narration of facts. I gone.
Ask your junior to inform Mr. Tapan Mukherjee.
I went there, I have requested it, but I am coming. His quarreling is going on. The why matter would be mentioned, why matter would be taken up. I am convinced he is coming.
May I just give your lordship the basic facts? I approach the civil court. I shown everything that this is my ownership, and this property has been utilized for temporary purpose for these reasons. The civil court granted and status quo order. This was happened in 2023. By this time, 2023, they approach after the status quo order was passed. They approached the civil court by filing an 151 application for modification. Everything got clarified. They said, yes, very well, this portion, the status quo order is subsisting. We do not want the status quo order to be violated. Allow us to use the plaintiff's land for a temporary purpose for this jetty. Granted permission 2023. Similar in 2024. Now 2025 also the same thing happened. What I say if, because this portion, this stretch of land, if being used every year for the purpose of holding this Gangasagar Mela, then let this land be acquired as per the law. Because I am not going to enjoy my property, because in every year you are going to use this portion of the land for the purpose of ingress and egress to the temporary jetty number 5. If this is the position, I have purchased my land, let the rest portion of the land remain with me. I can enjoy, I can construct also. Yes. Because today I am not in a position to apply for a sanctioned building plan. Because today they are...
You have a sketch map.
Yes. Kindly takes up my representation.
Sketch map there.
Page 67, your lordship kindly takes up.
67.
Yes. Sketch map. Just after page 70.
There is any sketch map? No.
In the plaint. Subject to correction.
No, in the plaint, it was your allegation that they are trying to trespass a particular portion.
Trespassed, already trespassed. Yes. For temporary period.
No,
it's
have
not.
You identified that portion which they are utilizing for this purpose of going to the jetty in the plane by way of a sketch map?
No.
That you have not done.
But my lord, in 151 application, they themselves have stated.
Admitted.
Yes, where is the 151 application? They have given a sketch map in 151.
No. In the 151, they have not. But my lord, in my representation, I have given. But my lord, they have mentioned, my lord, the how much area they are enjoying. Kindly takes up page 54. It's 2023 modification application under section 151.
Page 54.
Yes. Has your lordship got it, Lord?
Yes.
May I place that? May I place, Lord? This are relevant. উক্ত মোকদ্দমায় 1 ও 2 নম্বর বিবাদী পক্ষের নিবেদন এই যে উক্ত মোকদ্দমায় বিবাদী পক্ষের ইনজাংশন আদেশ প্রাপ্ত হইয়াছে। উক্ত আদেশের বিষয় এই বিবাদী পক্ষ সম্পূর্ণরূপে অবগত রইয়াছেন। তপশিল ভূমির ওপর দিয়া প্রতি বৎসর গঙ্গাসাগর মেলার সময় লট নাম্বার 8A 5 নম্বর ভেসেল ঘাটের যেটিতে অস্থায়ীভাবে যাতায়াতের ব্যবস্থাপনা তৈরি করা হয়, তাহাতে উক্ত রাস্তা হিসাবে ব্যবহার করিবার জন্য বাদী পক্ষের তপশিল ভূমির পরবর্তী ভূমির মালিক পক্ষগণ পারমিশন বা অনুমতি দিয়া থাকেন। সে কারণে বর্তমান বৎসরে 23/12/2023 তারিখ হইতে 23/1/2024 তারিখ পর্যন্ত গঙ্গাসাগর মেলায় লট নাম্বার 8A 5 নম্বর ভেসেল ঘাটের যেটিতে অস্থায়ীভাবে যাতায়াতের অনুমতি প্রদান করা একান্ত আবশ্যক, আদালতের দিয়ত ইনজাংশন আদেশ লঙ্ঘিত হইবে না। নেক্সট ইজ ইম্পর্টেন্ট, মিলট কাইন্ডলি মার্কস ইট।
Tapan Mukherjee is on leg mallet on court number 4 mallet.
Police
Junior is assisted by junior.
And police
ঠিক আছে, আমি শেষ করব।
আর তোমারটা করো, তোমারটা না না সেটা মাইলটকে বলে দিলাম।
ভেরি ইম্পর্টেন্ট, মিলট কাইন্ডলি মার্কস। প্রকাশ থাকে উক্ত রাস্তাটি মেন রোড হইতে 40 ফুট চওড়া করিয়া যাতায়াতের উপযোগী করার আনুষঙ্গিক যাহা করা প্রয়োজন তাহা পশ্চিমবঙ্গ সরকারের পক্ষ হইতে
যাহাতে করিতে পারে এবং পূর্বে উল্লিখিত তারিখের পর পুনরায় নালিশি দাগের ভূমিতে পূর্ব অবস্থায় ফিরিয়া দিতে পারে তাহার আদেশ প্রচার একান্ত আবশ্যক। So 40 feet your lordship already get.
No, 40 feet,
That's
that identification.
Yes, Milord kindly takes up now my representation, the sketch map annex there to just after page 75. I will show before your lordship that portion. My calculation is also based on there, Milord.
Yes.
My lord kindly takes up, Milord, the bottom portion, the Mela, it has been written, Milord, in the bottom portion just prior to part of RS plot number such and such.
RS plot number 295.
No, Milord, 305.
Yes,
Bottom,
305.
just above that, my lord would get, Milord, a portion is being delineated 40 feet and 164 feet. Has your lordship 40 feet width and 164 feet at a stretch length.
Oh, this
yes, only
yes,
those
way to way to Gangasagar Mela.
yes, way to Ganga. Existing main metal road.
Metal road.
Yes, just
And this is the existing metal road. Where is the jetty?
jetty is below.
Yes, temporary jetty is after that.
After that. So my
We are trying to connect this to metal road.
yes, 40 feet width and 164 plot at length. Milord, I have mentioned.
So you are the owner of which plot?
Milord, this Milord, myself is the owner of entirety this portion at a stretch which has been, Milord.
No, you are the owner of this portion plot of your Topongiri.
Yes,
Yes, Topan.
so I have annexed my deed also.
Did also.
No, so only a portion.
Yes,
Mr.
only a
Mukherjee,
portion.
they are utilizing a large tract of this 40 feet. So a portion of that belongs to you.
No, mine is 40 width and 164 at a stretch.
164. Yes, that
And
is
thereafter also, Milord, there are other plots.
that is
I'm
what
not
I'm
concerned on
saying. So you are only on 40 feet by 160.
Yes, 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 yes. And my
falls within your property.
and admittedly, Milord, in 151 every year they are asking permission.
All right. So, but you are saying that you cannot utilize your balance portion. Why?
No, Milord, if this portion in every, Milord, if in this is, Milord, kindly see, this is the metal road and this is the portion over which, Milord, my gates are installed. If they are going to,
Your gates are installed where?
Milord, in this portion, Milord, in the just in Mela, it has been written Mela.
Yes.
This portion is, Milord, where, Milord, my gates are being
You
involved.
have not indicated the gates.
No, no,
here.
no.
No sketch.
I have not. But, Milord, if I want to construct over my property, I have to delineate which portion I have to construct. Today, Milord, they are saying 40 feet and 164.
Mr. Mukherjee, you have your ingress and egress from the existing metal road. Even excluding this, because this is a part, because you do not have any access, because on the southern side of your plot, there is also another plot of a party. So you do not have any southern side.
Grievance, yes.
So it's on the western side, you have an access to the metal road.
But, Milord, there, I
And,
take your lordship to 151 order once, because the learned trial judge has taken care of my access also in 151. My lord kindly takes up, Milord, page
The
65.
order passed under 151.
Yes, yes.
Where is that?
Milord kindly takes up page 65. The order starts. I will take your lordship only the operating portion at page 66.
Yes.
Has your lordship? Yes. Milord, the operating portion, after the ordering part, the defendants are permitted. Has your lordship got it, Milord? The defendants are permitted to make temporary arrangement and use a portion of the suit property for the said periods for a purpose of communication to jetty number 5 at lot 8, leaving a portion thereof for the use of the plaintiff for his smooth ingress and egress to the dwelling house. So, Milord, this portion has been taken care of also by the learned trial judge.
Yes, yes, but Mr. Mukherjee, the difficulty is in this sketch map, where is that portion which is to be left? That has not been indicated.
No, that has not.
Oh, that's
Today,
vague.
Milord, yes. Milord, today
So-
my
so-
difficulty is, Milord, suppose, Milord, today the government is saying, I need for this temporary jetty ingress and egress 40 feet and 164 feet, whatever. Tomorrow they can say, no, it is not 40 feet, now we need 60 feet. This can be at the whims and choice of the government. I say if it is really required for you for the purpose of organizing this mela every year, why not a proper acquisition process? Why this? Today I have gone to the civil court. I have protected by an order of injunction. But what is the use of that order? Because every year you will come and invite the court that, look, I know, Milord, this is a holistic reason. I cannot stand in the way. If you want entirety of my property to be taken away, please take it. I know I cannot stand. It's a public purpose. This is a mela sentiment. I know, Milord. That's why I say, Milord, this is a perennial problem. If you really want, if you really want to organize,
What is your prayer in this?
yes. Sir, kindly take up page 12. The first prayer itself will do.
Where is your plaint?
Plaint, Milord. Page 30 it starts. Because, Milord, when the plaint was drafted, that time one trespass is being done, and I was not in a position, Milord, to explain or to describe what is the real necessity. Once every year this happened. So today the picture is very clear to me.
Please give me a minute.
Fine. My lord.
Cost schedule and cost schedule.
Yes, Milord.
Page 49. 49.
Cost schedule, my lord, would get it's the entirety of the property.
Yes. And what is the
66
cost schedule?
decimal, 66 decimal, Milord, which I have delineated. উত্তরাংশের 1 একর 14 শতক বাদে দক্ষিণাংশের 66 শতক, Milord, this according to me, which has been utilized in 2022 beyond my permission, because that was the cause of action for bringing the, Milord, suit before the learned trial.
What is the cause of action for the suit?
Suit because in 2022 initially this trespass was happened without intimating me anything.
Yes.
I rushed before this honorable court, read petition, this honorable court said civil dispute, go back before the civil court. So I immediately gone back before the civil court and file a suit stating that in 2022 this portion is being utilized unauthorizedly by the state authorities without intimating,
So
without my
that
permission.
is 1 acre 80 shatok.
No, Milord, 1 acre 80 শতক is the total area which I purchased. তার উত্তরাংশে 1 একর 14 শতক বাদে দক্ষিণাংশে 66 শতক. That is the B schedule.
So B schedule is that 40 feet by 164 feet.
Yes. I say, Milord, there may be a miscalculation at the time when the suit was being filed, but today, after 151 application is being repeatedly filed, it is now being admitted position that 40 feet and 164 feet as a, Milord, length and breadth they needed, at least up to this year. Up to this year, even, Milord, in 2025, the same stereotype thing happened.
Where is the order passed for this year? 151.
That is, Milord, Milord, my junior has handed over, Milord, to your lordship.
আমাদেরকে দিয়েছিস
This year,
কাকে দিয়েছিস
আরে তুমি কি নেবে?
হ্যাঁ।
তো আমার দিকটাও নিয়ে নিয়েছি।
আচ্ছা তাহলে এটাই দিয়ে দাও আর
Milord, kindly accept this.
No. I think is it this 2nd of December 2025?
Yes, 2nd of December.
তুমি নেবে নাকি? আচ্ছা না, তোমার খুব ইচ্ছে হচ্ছে না, তুমি তো প্রতি বছরই খেলা চালাচ্ছ না।
Same order, Milord, your lordship can compare with it. 2023, 4, 5, same order.
Yes, Mr. Mukherjee.
মানে এটা গঙ্গাসাগর মেলা under the particular statute and this for only for a limited period. for 15 days or maximum 1 month. But for that purpose, no, is not, the government has not decided for acquisition of the property, number one. Whatever the civil court has passed an order, since I do not know, because this order is passed only on 2nd December. Whether appeal has been preferred or not.
There's only one thing. Every year you want this is a continuous process. Maybe for 15 days or 1 month. So according to you, it's for a temporary purpose. So which statute gives you a right to utilize a citizen's property even for a temporary period?
No. If for 10 days or 15 days or 100 days, for any purpose, government wants to use this, that must be a notification issued. A decision must be taken by the government, whether we acquire or not, or different chapter.
There are two separate aspects. One is acquisition. One is to utilize a portion for a temporary purpose. So under what authority you can do this? Please show me, because you are the state, you are an authority. You have to show me the power. Please show me the power.
What right he has got? He has purchased the land. He is a riot. Nothing more. He is a tenant under the government.
Everybody is a tenant under the government.
Yes.
So you can utilize that.
No.
Without.
No.
Under what process? Mr. Mukherjee, there has to be a process.
Process for, if the government wants to acquire it, there must be a
let us forget for the time being. Let us accept your submission that the government does not want to acquire.
Yes. Now, that will be the decision to be taken by the government.
Yes.
Not by a particular officer. It will be
No, not by a particular officer. It has to be of the government.
Government.
But you have taken a decision to utilize this property. Who has taken this decision, and what's the authority under the statute?
That I should have obtained. Call for the records.
So which statute gives you a right? It's a legal point. Then factually I will come. Show me under which statute gives you a right to utilize a private property for a temporary purpose without paying anything. Please show me.
No, but a Gangasagar Mela, there is a particular statute is there. And I'm not sure whether Gangasagar Mela provides any temporary acquisition or not. I'm not sure about it. But this particular...
Because Mr. Mukherjee, I'm not concerned for 1 year. Because every year this is continuing. And this will continue.
No.
For coming years also.
No. Then in that
be something, a concrete thing has to be done.
Yeah, but then
you have to acquire, you don't acquire any temporary measure, because something has to be done. Because what is the extent, where, and what should be the arrangement? Every year you will be utilizing without making any compensating. That cannot be done.
No, in that
you have to do some act.
Yes.
You have to show me the power
of the government,
where you derive
power of the government to utilize this particular portion of the land belongs to
what authority?
Under authority. That is the only question. So far as this year is concerned, now the Gangasagar Mela has already been, pilgrims are coming from different parts of India. Now it is very difficult for this year. Let the government take a decision and communicate to my land friend or before your lordship.
That will be communicated. That is a different chapter altogether. Please show me the power first. I can keep it on another day. I'm not disturbing this for the present, but please show me under what authority you are doing, because this has to end someday.
Yes, I shall have to after, because the district
must kept quiet, Mr. Mukherjee, only by filing 151, taking these orders starting from which year?
2023.
2023, 2024, 2025. So unless it is stopped at some point of time, it will continue. So let us start from today, because some decision you have to take.
Yes, certainly, madam.
So please show me the power in which you will be exercising.
At present moment, I'm handicapped because there is a particular statute, Gangasagar Mela.
All right, so I'm keeping it on another day. Mr. Mukherjee, considering this
I am not standing.
purpose.
I started my submission, Lord, yes. I do have also, Lord, some sentiment with that. So, my lord, I cannot, my lord, be, I means not myself.
You
my
have
lord,
paid for
my-
any interim order? No.
No,
No.
I have.
I have not paid for any interim order.
I have. That's right. Right, fine.
Take care.
No, my lord, I have
Mukherjee,
prayed, but I am not pressing for the time.
of the suit also. Nothing remains in the suit. So the suit will, because something permanent arrangement has to be done.
Yes.
Because also he cannot utilize, please consider his predicament. He cannot utilize that portion.
But assuming for a moment that government has no power to take over possession without taking recourse to law, just I'm taking that. The land is there. More than 5 lakhs people are coming, passing through this particular portion. Who will prevent it?
Mr. Mukherjee, I know how to prevent. You take that stand, I know how to prevent.
And
I've
never I've seen Ganga Sagar Island. I've never seen Ganga Sagar Island once, more than 25 years back.
If you take that stand, I know how to prevent that. That much I can assure you. That much I can assure you.
Why providing?
Because Mr. Mukherjee, you
Safety of the people is very much important. Safety of the pilgrims is very much necessary.
yes, that is there. You can make arrangement because something every year, something has to be done. If you need, you take a decision with regard to that. Whatever,
Yes.
you take a decision with regard to that. Because if that portion is necessary, you can acquire that portion. You can utilize that for a permanent thing. Why temporary thing?
পার্মানেন্ট যেটি আছে অনলি ফর এইটা ছাড়া ঠিক আছে যেটি
Or you can take other decisions what the statute provides for
For.
that. Because you cannot take any steps which is not provided under the
No, government cannot take without recourse to law.
yes.
That is the settled principle.
Yes.
But when people are coming, passing through this portion of the land,
They are passing because there is a temporary J2 constructed by them.
চারটা যেটি আছে এবং অন্য ফার্ম যেটি আছে
just give me 1 second. And then keep on putting it. Some personal difficulty.
যাও
14th.
I say that 14th is the date of Sagar.
We are not saying.
Interim order, Mr. No. Everybody is saying 14th is a holiday.
No, Pongal. Post Sankranti.
It's not a holiday. Someone said that it's a 12th holiday declared by the state
No.
government.
No, state government.
Submitted in open court today.
No, but I'm not sure about the state government. But I've heard that is a 14th and 15th is a Pongal holiday in other states.
We have, I've been informed that the state government has given a holiday, declared it as a holiday on 14th. That is why it has been said, don't fix it on 14th, it's a holiday. That is what I am asking you, since both of you are here, I am asking you whether the 14th is a declared holiday.
No.
19th,
19th have some personal difficulty.
20th,
20th or 21st? 21st January.
Commissioner has raised a serious issue in this writ petition. Petitioner filed a title suit being number 99 of 2023, which is presently pending before the Learned Civil Judge Senior Division, Kakdeep, District 24, Pargana South, praying for declaration of title and for recovery of possession or permanent injunction. Declaration of title in respect of co-schedule property and for recovery of possession in respect of co-schedule property. Mr. Mukherjee,
Milord, kindly,
here
Milord,
is-
Priya, Milord, I have not prayed for.
yes, খাস দখলের ডিগ্রি।
ক্ষতপোষিল বর্ণিত ভূমির বাবদ খাস দখলের ডিগ্রি।
Yes, what does it mean?
But Milord,
Not recovery of khas possession. Then,
but Milord, kindly see prayer go.
no, prayer go is not to change the nature and character.
And also Milord, that তপশিল বর্ণিত সম্পত্তিতে ভোগ দখল করিতে না পারে বা রূপান্তরজনক কার্য করিতে
Yes,
না পারে,
that is changing the nature and character, not to possess, but you have been
not to possess.
dispossessed.
Yes. But it's for the time being I dispossessed.
So if it is dispossessed, Mr. Mukherjee, you
No,
get
it's-
your relief in the.
No, Milord,
you get your-
subsequent 151 kindly see. Subsequent 151
remedy
clarifies everything.
Mr. Mukherjee, for that remedy lies elsewhere.
No, I am not.
Now,
Yes,
if
Milord,
this
my
is your prayer
amendment-
in the suit
Milord,
for
they-
recovery of khas possession, you are dispossessed
that-
now.
they-
So can you now claim? So
Because
if
of
you have
Milord-
been
Yes,
dispossessed,
Milord,
in your
technically your
possession.
lordship is absolutely right. But Milord, kindly see the tenor of 151 wherein the learned trial judge admitted position, both the parties, that he will give back possession after holding Mela. And if in between anything happened, he has to pay the compensation for damages, for only damages, if any damage to the property is being done. But initially, when uprooted
Mr.
the
Mukherjee, don't invite the observation of
No,
the
I am
court
not-
with regard to that,
No, Milord,
because if this is your prayer, whether that type of 151 directions can be passed.
that Milord, on their instance, it's
Yeah,
151.
Mr.
Yes, I know.
I'm
Milord,
not opening my mouth.
No, Milord,
because,
I understand. Milord, I
that
understand. Milord, I will take out Milord appropriate application before the trial court. Yes, your lordship kindly do not, Milord. I will.
So if you are very much on that,
No,
then,
I will take care of this, Milord, because this was Milord at the Milord hottest when Milord this happened in 2022. I knew, Milord, that at that
till
time
2025, today, 2026, this day you have not taken any steps in the suit.
that's something.
Then
which
what
I cannot-
remains
That's
in
something
this
which
writ petition?
that's something which. But Milord, today also your lordship kindly consider this
Fight
thing.
it out, take this, make this
But
clear
I'm-
in the suit.
No, Milord, my suit will be, Milord, after this effort by your lordship, everything will be solved. Because Milord, this
Withdraw the suit and come.
my suit has virtually, Milord,
Withdraw the suit and then come.
withdrawing of suit, Milord, will.
Otherwise, Mr. Mukherjee, you continue with the suit.
No, I am
No
not on that.
difficulty.
Milord, today
Because with this
I am
prayer-
not on that. Today they have a hinge because of that interim injunction. That's why they are going and approaching one court. Tomorrow, if I withdraw the suit, Milord, that hinge will also go. Once, Milord, in 2022, there are 10 lakhs of Milord, valuable trees that has been uprooted by them. Till I am, Milord, going, Milord, pillar to post.
Appreciate that. But when you yourself admit you have been
No, Milord.
dispossessed,
Milord, by
how can
on that, I do not know whether that time that use was for a temporary purpose. I was not under an impression that government authority illegally has trespassed into my land.
thereafter also you have not
Yes,
admitted
Milord,
your claim?
I shall text. I shall text. On the next day itself, I shall come back, Milord, with that. I can assure before your lordship that today, Milord, this has been, Milord, this was also missed by me. I must be candid before your lordship. The immediate The order, your lordship knows me much better than us that these orders we have to support many times, because this is something your lordship's court and the Honorable Supreme Court laid down many times, but this we are helpless. This sometimes we are helpless. What can be done, my lord? This is something, my lord, your lordship has to infer somewhere. Particularly when in 151 they are admitting that yes, I want to utilize his property and thereafter I will give back the property. Today, my lord, under Article 226, my lord, your lordships, my lord, taught us many times that my power is enormous. Yes, your lordship's power is, my lord, no doubt. Why, my lord? Where there is a miscarriage of justice, where there is a, my lord, miscarriage of justice, particularly a fundamental right of a citizen.
Right to property is not a fundamental right. 311 capital A.
স্যার এটা নিয়ে আবার আপনি আর্গুমেন্ট করবেন, তাহলে আবার আমাকে দেখাতে হবে।
So do you want to file a report on that date?
Yes.
Later, who shall file this?
Collector and district.
The yes.
Great.
Great. Just call the next matter. আচ্ছা একটা উপরে একদম একটা লাইন করে দিন তো।
There is a arbitration order passed in arbitration proceeding. Arbitration proceeding was conducted by order of this honorable court. Lordship, may I just submitted one, may I be permitted to submit one judgment? Lordship, reported in 2025 for SCC online. 54, paragraph 54 and 55. My lord, my principle of natural justice has not been followed. Paragraph 54 and 55. May I be permitted to place the paragraph?
এদিকে একটা arbitration and conciliation act একটু দিন তো। Arbitration and conciliation. Here the award of the arbitrator was not under challenge in this matter. It's well settled that 226, 227 is maintainable if there is violation of the principles of natural justice. Under those four exceptions are there. I'm not for a moment suggesting that the availability of an alternative remedy is an absolute embargo. But Arbitration and Conciliation Act is a special statute.
Yes,
That statute provides for a remedy.
Kindly allow me. Page number 149 starts, only two lines I will show, Lordship. Kindly see. 149. If your lordship suggests that anything, allow me to submit a 140, page number 149 of my.
Please give me a minute. Yes, page
149.
page 149.
And impugn order, 21 April 2025.
Twenty-one.
April.
Yes.
Lordship, kindly third line. Petitioner C. Ambia Mondal is not present and absent on court. My lord, what happened? My lord, online they request me to present through online. I take this pleading my writ petition. My lord, uneducated people, lordship, kindly consider that. Right. On a call, my lord, I could not be present on online. My lord, this order was passed in my absence.
Please see 34(2) I. এটা দিন তো 34(2) I. There's a ground clearly, that is the ground available under section 34(2) I.
I lost my remedy already. 120 days from the passing of this order already on.
Yes.
So no, my lord. I have
Now you are coming and court cannot extend him in a single day.
My lord, may I submit one?
There is a bar of limitation and there are also judgments.
I am
Supreme Court judgment which says if you have approached the court after the expiry of the period of limitation gone.
No, I am approaching before your lordship within period of limitation. Why I am saying lordship, although order passed on April 21, it was communicated to me on just 28/7/2025, page 153. So I am this.
When have you filed this writ petition?
Yes, it was filed December, just expiry before expiry of 120 days. And see, just
120 is not automatic. 120 is not automatic, it's 90 days. 30 days is a condonable period upon sufficient cause being shown. Limitation period is not 120, sir, it's 90. Can be extended for 30 days subject to certain grounds. That's the difficulty.
My point is only I have
without
not
looking at that, you are filing writ petitions, you are
not kindly
destroying your statutory rights.
kindly consider that I have not been given any opportunity of hearing also before the arbitrator.
That's specifically, that is what I've shown you.
And
That's the ground available, specific ground available under 34(2)(3). Very wide, all grounds are available under 34(2)(3).
My case was referred to the arbitrator on the basis of the court of order passed by this honorable court.
Yes,
This
but-
honorable court has also directed my lord given opportunity of
Lordship, I had sought time yesterday, Your Lordship, to seek instructions. When I sought instructions, Your Lordship, I was told that the order is reasoned, Your Lordship, and that they had not appeared despite service to them for appearance.
Not appeared, can you not reconsider that? Because
Lordship, I can seek instructions and come back on that, Lordship.
take instructions because why did you not appear?
This was an online mode. My lord, he asked me to appear online. My lord, due to internet disruption, I was not able to connect.
Because this
But I
is a,
take that
failed
pleading.
to appear. If it can be done, if you hear him,
Any day, lordship, any day fixed, I will appear and.
Lordship, I'll seek instructions and come back on that.
instructions if because he was not present. He is also not disputing that notice was served. Notice was served, but even then, there may be, even if notice has been served, there may be very many reasons for which he could not appear. After all, it's an ex parte order. If you can reconsider that and pass an order.
I bow down, Your
Please
Lordship.
take instructions.
I'll take instructions and come.
matter.
Number 18, my lord, I am praying for my lord, not this week, my lord. My lord, due to certain death rituals of my lord.
On 2nd of January, it was also adjourned.
Yes, ma'am.
My lord, due to the unfortunate, my lord, death rituals to perform some death rituals, my lord, my Mr. Ashim Kumar Raut has been into native village, my lord. He went to my lord native village to perform his, my lord, near relative death rituals, my lord. And on that
Yes,
ground,
what is this matter, Mr.
My lord, 10-4, there is a 10-4 was there, my lord. After that, my lord, they filed various grounds, my lord. He wanted to delay this.
Where is the
matter.
order of passed under 10-4?
That is
10-4 order.
If your lordship will see.
What is your name?
Page, my lord, 130.
Tubhayan
Last
Barik,
page, my lord.
Tubhayan Barik, my lord. I am the
You are the advocate on record.
my lord, but my lord,
My lord, your lordship will see 132, my lord.
Page
That is-
132.
130.
Yes, my lord. That was challenge.
Yes.
He was asked to appear before that 10-3 officer, subdivisional officer.
Yes.
He refused to do. He challenged that.
No, yes, challenge this notice.
Yes,
My lord, notice has been challenged.
Notice
I am the
challenge, my
private
lord,
respondent.
and delayed the matter, my lord, for a long time.
After this 10-3 order has been passed.
Yes, my lord. After, in spite of that, my lord, 10-3 order was asked him to come to the office, but he challenged this.
So now, did he? Has any order been passed?
No, my lord, nothing was, as he did not appear. As well as to file this application.
And
my lord, it is not.
encroachment has been identified, my.
Yes, appear before the authority.
Yes, my
You
lord.
have to
That
appear
is the
before the authority.
Yes,
The
my lord.
right of
the
yours
main
has
thing.
been affected
My
by
lord,
this.
10-3 proceedings has already been concluded, my lord. As per
No,
in the previous
that is
petition.
the
Show me when order was passed. Give me the order. If that order has been passed, you prefer an appeal.
Now,
Then this writ petition has become infructuous.
My lord, come.
no
Then this
132
writ petition has become
My lord,
infructuous.
is
If
a notice,
accordingly
my lord.
The order has been passed. This writ petition has become infructuous then.
My lord,
Is
kindly
a
come to
notice.
Page number 131, my lord.
10-3
131,
notice.
yes.
Conclude.
My lord,
My lord,
or
in the
that
11
PRA, my lord, 23. If your lordship will see PRA, so cause. Your
My lord,
lordship
kindly
will
see
see
paragraph number 11, my lord. My lord, before
He's
parting with it is, however, made clear that the disposal of the instant writ petition in the favor of writ petitioner shall not have any effect in the proceeding before the respect number 7 authority under section 10(3) of the said act, hearing of which has been claimed to have been concluded. my lord.
Yes, hearing concluded. So where is the order? Any order has been passed?
No, no.
That I- my lord, that
If the hearing, you
order.
have participated in the hearing. What remains? How can we challenge now that?
Around.
my lord, the notice which was issued, my lord, is for hearing, my lord.
Yes. So why are you challenging that? You will not attend the hearing.
My lord, the it was claimed that already concluded, my lord. The proceedings have been already concluded. After that, my lord, notice of hearing.
Did you participate in the hearing? Yes or no?
That I don't have the
Well,
instruction.
he has participated.
That I don't have the instruction.
I am the private respondent, well, both are participating.
Show me that you have stated that this notice was served after the date of hearing. Show me that. Show me the averment.
Kindly
Paragraph
Preferred a
29.
statutory appeal.
Paragraph 29.
21, you have preferred a statutory appeal under 10(4). Statutory appeal was heard. It's pending.
What
have you done? This is a notice under 10(3).
Yes, ma'am.
You have challenged the order notice under 10(3) after the order under 10(4) has been passed.
10(4) order has
Please
not.
kindly come to your paragraph 21.
My lord, as per order of the Honorable Court, my lord, 10-3 was started again.
Yes. After
That is
setting
the-
aside
your
the
lordship
order
will
of
see-
10-4.
Yes, my
My
lord.
lord.
After
Yes.
your lordship will see the page 127, annex at 16. That is the order of the Honorable Justice Chen.
Yes, yes, I'm looking at that.
And last.
Fresh hearing for 10-3 will be on.
Fresh hearing. And after that, notice was issued.
Yes. So this order was passed when?
When, my lord, that is 28th August.
Of August
2025.
Yes, my lord.
Now, thereafter, the order notice was
17th November.
17th of
17th
November, asking him to appear on 16th of December 2025.
Yes, my lord. He challenged that.
Yes. What is the ground of your challenge in this notice? Why have you challenged this notice?
The ground was that, my lord, the 10-3 proceeding was already been concluded.
Sir, initially a 10-3 proceedings was concluded. You preferred an appeal.
Yes.
10-4. That order was passed. You came up in the writ petition saying that during the pendency of the writ petition, 10-4 was passed. The court had set aside everything, then directed you to appear in the 10-3 proceedings. Please kindly come to the page 130.
32.
While disposing of permitted,
Yes, my
the
lord.
writ petitioner and the private is to participate in the proceedings before the authority on a specified date. Accordingly, the writ petition is hereby allowed. The order under challenge dated 22nd of April is set aside. All consequential actions taken by the, including the pursuant to the order dated yes, Mr. The 10-3 order was not set aside.
No, my lord.
So then,
First, my lord, after that, my lord, he challenged that 10th, there is some difficulties.
no, 10-3
For
has not
appeal,
been
my
set
lord, that if
aside.
your lordship, the court while disposing WPA 20-204, that is also permitted the present 130, my lord, if your lordship will see.
130, yes.
That is, the order dated was passed by the respondent number 2 authority in an appeal of 10-4.
Yes.
10-4, an act when the operation of the impugn order before him was stayed by this Honorable High Court in connection with that. My lord, before that, my lord, in this case, my lord, that was stayed. But appeal was, my lord, order was passed. That the court, while disposing of the author, permitted the present writ petitioner and the private respondent hearing to participate in the proceeding under section 10(3) of the said act before the respondent number 7 authority hearing, that is specified date of 15/5 to 2005. Honorable
Order
court,
under 10-3 was not set aside.
no, my lord, that is
10-4 set aside.
court set aside.
10-4 has been set aside. How do you issue a notice
No,
under
no, my
10-3?
lord, as because my lord that fresh 10-3 notice was issued as the last portion. If your lordship will see, before parting with, that is 11. It is, however, made clear that the disposal of the instant writ petition in favor of the writ petitioner shall not have any effect in the proceeding before the respondent number 7 authority under section 10(3) of the said act of hearing, of which has been claimed to have been concluded. Court, my lord, directed to fresh hearing, as because his claim, my lord, that there is some deficiency or other.
Confusion in this order, but 10-3 has not been set aside. Order is confusing.
But 10-4, my lord, 10-3, that is, he previously, my lord, he challenged the 10-3 and 10-4. And as per order of the Honorable Court, my lord, Justice Sen, my lord, that is how we started the proceeding, that is 132.
No,
And he challenged that.
Justice Sen observed that only hearing has been concluded under 10-3. But that's not the fact. Order was also passed.
Order was also passed in the.
Because after that, Mr. The 10-3 order was passed. Thereafter, he challenged in 10-4. Now, thereafter, he came before the writ court. Or he challenged that order. Where is the earlier writ petition?
That is 2024.
18229 of 2025, where is that?
That is, my lord,
Page
118.
Page?
Page 118.
118.
Yes, annex that writ petition.
The order was in.
Order was.
No, order I have got. Where is the writ petition? What was challenged therein? Quashing the order of under 10-4 only.
In this matter, my lord, 10-4.
So 10-3 order was not challenged. 10-4 order was challenged, 10-4 order was set aside. So 10-3 order remains. 10-3 order remains. How can you issue a notice under 10-3 for hearing? That has not been set aside.
On further perusal of the notice dated after it reveals the further that is fixed date of hearing of 10th of the said of hearing.
Order dated be communicated by the editor shall not be set aside and quashed.
Mr. The 10-3 order was not set aside. Only 10-4 was set aside. If that is so, how can you again issue a fresh notice?
এটা কবে কাজ 15 July. My lord, earlier read petition kindly. If in order has been passed. আচ্ছা 10-3 অর্ডারটা কোথায়? কোনটা 10-3 অর্ডারটা কোথায়? সেই অর্ডারটা কি সেট অ্যাসাইড হয়নি? এটাকে তুমি টেম্পোরারি 10-3 অর্ডার 93 না এবার এই মালটা খারাপ
Yes, only 10-4 order, Mr. Dev was challenged. So 10-3 order was not touched. If 10-3 order was not touched, how could you issue a fresh
But
notice?
if your lordship will see the order of the 20, that is the page 118 to come ordering portion, my lord, that is page 122.
122. Yes, 122.
That is on careful perusal of the aforementioned legislative provision. If I look to the factual aspect of the case, it reveals to its court that by issuing a notice dated ato, one notice was issued. The respondent number 6 issued a notice dated ato asking the writ petitioner to remove the encroachment in provision of section 10(1). On further perusal of notice dated ato, it reveals further that the respondent 7 fixed a date of hearing of 10-3 of the act wherein both the parties are appear. In view of such, and in absence of any materials to come to a finding that the aperture two notices are either illegal or illogical, or also in view of the fact that the writ petitioner have miserably failed to prove at least prima facie that the aforementioned plot of land is Rayoti land, this court finds no cogent reason to interfere with the aforementioned two notices dated ato. In view of such, this court finds no merit in the instant writ petition.
Then next page.
Yes, my lord. Along with the interlocutory matter, before parting with, the court directs the present writ petitioner as to private respondent number 10 and 11 to authorize the ato to appear before the respondent number 7 authority on May ato or on subsequent date at the time would be fixed for ato for participating ato. For this, my lord, this court, my lord,
Yes,
directs
so
that
10-3 asked them to participate. Then they participated.
Yes, my lord, participate.
Then order was passed.
It is
No.
not an order. My lord,
Because
now, in the event to read the petitioner to private respondent failed to appear before the respondent, failed to appear, my lord, on the day of
no,
fixed
if
by
they
the
fail
ato
to appear,
by the respondent number 7, the respondent number authority at liberty to proceed with the respondent number 3 and said in absence of the petitioner and private respondent shall come to a logical conclusion of ato. That is also 10-3, my lord.
Yes, that was in the earlier writ petition.
Earlier writ petition, my lord.
Then,
The time limit that fixed by the court is mandatory and ATO. This one 6 are directed to ATO. It is made clear that till passing the final order of the ATO of the date by the respondent. Number 7, there will be an order of status quo upon the aforementioned plot of the ATO in the writ petition.
and when the order under 10C was passed,
10-3 was
Passed on, my lord, page 93.
on what date?
দেখতে পারো
এ বাবা, ডেটটা এমন লিখে বুঝতে পারছি না।
দাঁড়াও, কত 93?
হ্যাঁ, হ্যাঁ। ভালো দেখাবো। বোঝা যাচ্ছে না।
25 March.
So this is on 5th of May.
5th of May 24.
No, no.
এটা 24 টা বোঝা যাচ্ছে লাস্ট ডেটটা।
না, এটা হলো 2024 to 6/8/24
August 2024.
6 August 2024
6 August 2024.
Oh, so 10C was directed to be reheard.
Yes, my lord.
My lord.
And in the meantime, my lord, appeal was there and appellate court also
So
passed the order.
10C was also set aside.
Yes, my lord.
My lord.
As because, my lord, he is not appeared on that day and other things was there. And but that order, this order was, my lord, challenged by the 10th court and that was challenged with the Honorable High Court. My lord, at this time of the stay order, the order passed, so in the next case, my lord, that was set aside.
এখানে কোনো জায়গায় লিখেনি যে 10-3 অর্ডারটা সেটা সেটা 10
So thereafter, no order under 10C has been passed.
No, my lord.
But that is, my lord, we issued that
Notice.
Yes, yes, what is the submission?
I'm praying for adjournment, my lord.
So on the last occasion also you have paid for an adjournment. This cannot go on.
My lord, it was so unfortunate, my lord, unfortunate incident, my lord, for unfortunate death rituals, my lord. On that ground only, my lord. Kindly have the last one.
Advocate on record. You have to have been ready.
Don't have
Then
any.
he will be available.
Next week, any day, my lord. Next week, any day, my lord. Any day, as your lord says, please, my lord.
An accommodation. It is there.
Yes. So.